17, it indicates, my lord, the actual need or urgency felt by the landlord, my lord. The seriousness, it is a private litigation between the private parties. So the passion in pursuing the litigation, my lord, or the conduct is always assessed by the court every time. The seriousness, my lord, of the plaintiff landlord is apparent. My lord, suddenly, my lord, they have awakened from the deep slumber and come to the court and approach that occupational charges are required. Why? It is in Bhavanipur, ground floor, 3 rooms, and 2 or 3 my lord examples that how much rents they are fetching from the other landlords, everything, without describing the actual condition, be that as it may. Look what this is.
Are they entitled or not?
Not entitled. Why I'm saying? I'm coming.
Not entitled.
Not entitled. Why I'm saying that? My lord, yes, my submission, my lord, will be compartmentalized, my lord, because first of all, the point of limitation, whether the limitation applies. Second point, my lord, the waiver and acquiescence, because it is a personal right, landlord-tenant relationship, and if it is barred by limitation, the other points are not required to be gone into by the court. And, my lord, this personal right is a known right. In this known right, my lord, it indicates that it is a volitional relinquishment of a known right, personal right. It is an abandonment. Law gives them right. 31st July is the first decree. It was dismissed. 30th June 2006 is the decree passed by the appellate court. 22nd March 2007 is the order of admission. 2017 after 10 years. Why I am saying so? Section 3 of the Limitation Act. This point was argued. It is not that I am making any new horizon. And this point has been approved by the Honorable Court. Your coordinate bench of your Lordship's Court went to the Supreme Court affirmed.
In this list? In this list?
In a different list, the same facts, occupational charge. I argued this matter with I and Piyush. Miller, subject to provisions. দাঁড়াও না একটুখানি, দেবো তো সব কপি, দেবে তোমাকে, না দেবার তো কথা নয়। লিমিটেশন একটা কপি তো হয় না, দেখাবো তো, আনরিপোর্টেড জাজমেন্ট নিশ্চয়ই দেবো। তোমাকে বাদ দিয়ে হাইকোর্টে কেউ চলতে পারে না। Subject to the, may I read, Miller? Section 3. এই জজ সাহেবকে বই নেই লিমিটেশন, হ্যাঁ ট্যাবে আছে। Miller, may I? আর নেই না।
You have?
Miller, হ্যাঁ?
You have a?
Yes, when may I read and hand it over?
Otherwise, I'll put it out here. Yes, Mr. Basu.
Yes, Miller, at the cost of tiring repetition, your Lordship has taught us, Miller, from times immemorial, Miller, that limitation is a mixed question of fact and law, and Miller, are not meant to destroy the rights of the party, but it is meant to see that the parties do not resort to the dilatory tactics but seek remedy promptly. And it is a cessation of Miller remedy, not the right. The bar of limitation, subject to the provisions contained in section 4 to 24 inclusive, every suit instituted, appeal preferred, and application, read between the lines, Miller, made after the prescribed period shall be dismissed, although the limitation has not been set up as a defense. Now, these are the conditions for the purposes of this Act and 4 to 24. Now, Miller, this is a legislative wisdom, Miller, which, Miller, casts a duty upon the court, Miller, to inquire the point of limitation, even though, Miller, the parties in the proceeding did not raise this point. Because it's a self-imposed inquiry, Miller. It's a request from the legislature to the court, Miller, while dealing with the issue, Miller, the court must inquire into the point of limitation only in order to ascertain whether the parties are serious about their rights, and such silence, stoic silence maintained by the parties in a proceeding where an individual right has been infringed or alleged to have been infringed, whether such silence, is standing on the floor of acquiescence, waiver, and estoppel. And if it is not pursued, what are the explanations that have been given? I would.
In which paragraph of your opposition?
Opposition, I said,
In which paragraph?
No, I said in the point of limitation.
In which paragraph of your opposition you have?
No, yes, no, because I said, I am not required to raise this point, because I said that although the point has not been set up as a defense. Am I clear? Although the point has not been set up as a defense. I said, now, 4 to 3 to 4 to 24, these are the sections which talks about the limitation. And the such act, the section 3, is supported by Article 137 of the Limitation Act. এইটু জজ সাহেবকে বইটা দিতে একটুখানি তাহলে সুবিধা হবে।
লিমিটেশন অ্যাক্ট অন্তত একটা বিয়ার অ্যাক্ট হলো
137টা কই গেল রে?
ওটা বলি অথবা বিয়ার
এই একটু জজ সাহেবকে দিন তো এইটা, তারপর আমি নিচ্ছি আবার।
লিমিটেশন অ্যাক্ট,
লিমিটেশন একটা বার কর না, ওই সময় বার করতে
You are referring to 3 years.
Absolutely. Any other application for which section 3 starts with suit appeal application? Cause of action arose year in the 2003 apparently. 2006 decree confirmed. Second appeal filed 22nd March 2007. 2017 this was it. So today I'm sorry, this is a judgment reported in 76 4 SCC, page 634, 3 judges bench of the Honorable Supreme Court, Kerala State Electricity Board, applicability. সব আছে না, দেখাতে পারবো না, দেবো একটু দাঁড়া, আর তা বলিনি বলতে পারছিস দে জজ সাহেবকে দে।
এই জাজমেন্ট গুলো you are supposed to provide us on prior.
Not proposed to, sir. Supposed to provide us, yes.
Yes, which you have not.
ওইখানে দা, ওখানে যেও না, ওদের কাছে যেও না, ওদের কাছে যেও না, এখানে দা। Now, first, Article 137 of the Limitation Act describes the relevant application as any other application for which no period of limitation is provided elsewhere in this division, while Article 181 of such and such describes the application for which no period of limitation is provided elsewhere in this schedule or by Section 48 of the Code of Civil Procedure. Now, why Section 3, Article 137 and this judgment could be read together, because the Section 3 of the Limitation Act, it prescribes, it gives a definite contour to your lordship, says it applies in respect of any application relating to claim. I am definite with humility and confident that this application for occupational charges is a claim. Is a claim presented to a court, because the court must be apprised of the claim. It must have 2 elements. One is the promptness of the parties in the proceeding, that assertion of right within a period of limitation, since it's an application. Second, this application gives rise to a claim. If it gives rise to a claim, no suit, no appeal, no proceeding, applies to, my lord, this Limitation Act or comes with the purview of Limitation Act, because, my lord, every claims must be standing on the floor of cause of action. The cause of action, my lord, arose when, my lord, the decree was affirmed, the reversed, 2003.
Is it not still existing?
It is a
Cause of action?
Cause of action, my lord, because otherwise, cause of action, my lord, it is existing, but otherwise, Section 3 and 137 meaningless. First of all, my lord, if your lordship has to consider whether it's a claim. If your lordship says the cause of action has arisen now, or it is continuous, that is applicable in a service jurisprudence, in the pensionary matters, in a deterral benefits. But in a civil suit, in a claim, because the principle of limitation applies there, even it does not apply there, particularly, that is the exception. But in a suit for specific, in a suit against alleged trespassers, where it is a claim, otherwise, Section 3, 137, first of all, your lordship has to consider whether it's an application. If it is an application, then it's asserts claim. If it's a claim, then it's come under 3 subclause B, and irrespective of whether any defense made out or not. Third, that if there is no limitation is prescribed, today, my lord, it is very unusual, impractical, or unreasonable on my part or the part of the respondent, respondent, to conceive or perceive that this claim has suddenly generated. In the year 2006, 105 rupees rent, at least it should have been 2,300, 1,000, if according to them, if I go by them. I'm not admitting, assuming. At that point of time, they have relinquished. In 2011, after 5 years, with every year, it should have been there. In 2016, it should have been there. Every time you did not feel, suddenly, my lord, this cannot be related back to the past. Because otherwise, the intention of the legislature engrafted in 3B and 137, my lord, are meaningless. That means anybody can come anytime in connection with the appeal or suit for filing an application which essentially establishes a claim. So Article 137, Supreme Court in no uncertain terms says that relevant application, any other application for which no period of limitation is provided elsewhere in this division, while Article 181 of Civil Procedure 1900 Act described is an application for which no period of limitation is provided elsewhere in the schedule or by Section 48 of the Civil Procedure. Today, my lord, application includes petition. Kindly see paragraph 14 and 21. This derivation is changed and applies to the object tab to petition original or otherwise under special laws. Tenancy law guided by
according to paragraphs 14 and
21 also. And Article 137 also, my lord, para 18, it says, my lord, that it also includes, my lord, petitions within the words applications, the alteration of the division, as well as the change in the application of the words, compared with article in the Limitation Act, compared with Article 181 of 1908 of the Limitation Act, shows that applications contemplated under Article 137 are not applications confined to Civil Procedure Code. Now, my lord, there was no division at all. First of all, my lord, with deepest humility and respect, your lordship has to be satisfied. The language of the act is very clear. It is an inquiry incumbent upon the court, even if I do not take the limitation point. It is for your lordship. It is an imperative. It is a duty incumbent upon the court to inquire, even if no defense is there. If defense is there, then the application, petition includes application. It applies to appeal, application, and suit. If it is there, then application must generate a claim and reflects the claim. If it's a claim for which no limitation period is concerned, Article 137 comes into play. Am I clear? Next, this judgment I have relied upon. Now, my lord, the normal view of the Supreme Court all along, my lord, I have also won a case, my lord, in respect of a probate. I do not know whether an appeal has been filed in original side. Justice Rao has passed an order. My lord, normally, the legislature thought that there is no duty cast upon the executor or the the beneficiary of the will or the executor to come within a limited period, my lord, as prescribed under the Limitation Act, because Limitation Act does not apply, because making an application to the court is not a legal obligation. Supreme Court has answered this. This is 2020 12 SCC, page 480. 2020 12 SCC.
You're relying upon paragraph?
Yes. Millard, I have to read from Millard, paragraph 14.1, page 489. Permit me to read, Millard, for your lordship. May I start?
Yes.
When an application under section 276 of the Act is submitted for probate or for letter of administration with will, if any objection is raised by anybody with respect to execution of the will, in that case, the applicant is required to prove the will, and thereafter will shall be probated, and the court may pass an order for letters of administration. However, in a case where a will has been proved or deposited in a court of competent jurisdiction situated beyond within the limit of state, whether or within or beyond the limitation of India, in that case, as provided under section 228 of the Act, when a properly authenticated copy of the will is produced, the letters of administration may be granted in favor of such persons. Meaning thereby, in such situation, the will is not required to be approved again, and it shall be conclusive. Therefore, section 228 of the Act shall be enabling provision, and it confers an additional right to apply for letters of administration on the basis of such authenticated copy of the will. Therefore, as rightly observed by the learned single judge of the division bench, that 228 is akin to 276 of the Act. Now, the next question which may arise for consideration would be whether for an application for probate or letters of administration with will, the period of limitation would begin to run from which date. While considering the issue involved, the decision of the court of such and such is required to be referred to and considered. In the said decision, the court considered the decision of the Bombay High Court such and such, as well as the decision of the Madras High Court such and such. In the said decision, this court referred to and considered para 24 of the Madras High Court in such and such, which reads as under. In a proceeding, or in other words, in an application filed or grant of probate or letter of administration, no right is asserted or claimed by the applicant. Kindly, Millard, I put emphasis. The applicant only seeks recognition of the court to perform a duty. Probate or letter administration issued by a competent court is conclusive proof of the legal character throughout the world. An assessment of the relevant provisions of the Succession Act does not convey a meaning that by proceedings filed for grant of probate or letter of administration, no rights of the applicant are settled or secured in the legal sense. The author of the testament has cast the duty with regard to the administration of his estate, and the applicant for probate or letters of administration only seeks the permission of the court to perform the duty. There is only a seeking of recognition from the court to perform the duty. That duty is only moral and it is not legal. There is no law which compels the applicant to file the proceedings for probate or letter of administration with a view to discharge the moral duty. The applicant seeks recognition from the court to perform the duty. It will be legitimate to conclude that the proceeding filed for grant of probate or letters of administration is an action in law. Hence, it is very difficult to, and it will not be in order to constitute the proceeding for grant of letters of administration as application coming within the meaning of application under Article 137 of the Limitation Act. These courts approve the observation in para such and such insofar as the nature of the petition for probate grant of probate in administration is concerned. However, this court did not agree with the finding that application for probate or letters of administration is not covered by Article 137. Am I clear? So the first point, it is not a moral duty, legal moral duty, no legal duty. This is not application or claim in law and no legal sense. Even then, the court, Supreme Court says that I accept the Madras High Court's approval that it is not a legal duty, it's a moral duty. But court did not agree with the finding or the declaration of law pronounced by the Bombay High Court and Madras High Court, paragraph 24, that Article 137 does not apply. So court, Millard, did not allow any party to contest a proceeding, even if it does not convey any legal duty. So today, why, Millard, I find strength that is my submission, humble submission, my lord. Your lordship was shown the paragraph, the plaint, my lord, where the decree for main profit was given, prayed for. The main profit was the court, while passing a decree, appellate court, on 30th June 2006, they granted liberty to my learned esteemed friend's client to proceed a suit, my lord, for realization of the amount. It is their conscious choice not to, my lord, raise a claim against my client for main profit. There was no damage, although the prayer was there. They did not pursue their prayer. What is the ramification? What is the consequence of such silence? My lord, I put this question to myself. I repeat, my lord, at the cost of tiring repetition, these are personal, private litigations. Parties pursued litigations not like a game of chess, but in persuasive value. With passion. The landlord never felt any necessity of demanding, my lord, the alleged damage, although they claim. So it was painted with their imagination to impose, my lord, pressure on the tenant. They never pursued the. So what is I put this question to myself. So court granted you liberty to realize the amount. 2006.
So according to you, now they are barred.
According to me, what is the? I put this question: what is the ramification by not pursuing? Does it differ? The High Court, my lord.
Another citation. How many?
Of your lordship's coordinate bench. That's the Shamantu.
This is the second one. That will be the third one. That will be the third one. Any other on this point?
But I am not conversant with this branch of law, my lord. So your lordship kindly allows me to speak, my lord. Because I cannot match with his cerebral alacrity, my lord. I cannot match. Paragraph 12, my lord. Hey, ওকে দে সুতোবাকে দে।
দেওয়ার প্রয়োজন মনে করে না।
কিন্তু কি করছিস নাকি?
You were supposed to do it before.
হ্যাঁ? দিসনি তো? তখন দিতে ছেলে নেয়নি, এটা কোনোদিনও করে না।
Yes, Mr. Rosh.
Yes. এই এগুলো করিস না, ওকে খুব সেন্সিটিভ তো। After, if I start reading from paragraph 18, after thorough perusal of the proposition of law as discussed by the apex court in the above mentioned judgment, it appears Atmanan Properties case, the Honorable Supreme Court has clearly laid down the law. Appellate court is not ordinary to grant an order of stay merely because an appeal has been preferred such and such. Therefore, an obligate stay must do the equity the preventing on the facts and such and such, while passed in order made to be an operative of such premises or affirmment enforcement whereof to satisfy the demand of justice, the parties have successfully in the end of appeal. Thus, in the Atmanan property, the Honorable Supreme Court has put a justification upon the appellant court to pass an order of occupancy. In Vijay Kumar Shah, the issue was otherwise appellant, the landlord and intervention application seeks direction for payment of monthly occupational charge. It has discussed. So, deciding the issue, paragraph 20, it appears that in the suit for eviction, the trial court has denied the main profit. It appears the order April such and such, division bench directed to appellant go on paying of occupational charge at monthly contract, which lastly paid for. Here, Miller direction was also there. In considering the issue of modification, it appears was passed in the presence of the parties. The plaintiff was conscious about the order by the division bench. Though that order was passed in 2005, we have already completed 20 years. It is also admitted the market value of the such and such consciously enhanced considerably. But whether the equity as claimed by the petitioner can be entertained at the present stage such and such. The rent was mirrored 454, but at the same time, the power of the modifying the rate of monthly rate lastly paid can be modified such and such. Here, Miller, the order was passed, even then the court did not grant. It appears the purpose of is not an applicable in this case. The petitioner only seeking relief on the basis of equity. The equity as claimed is not at all maintainable. The petitioner is granted that it violates the directives of the consent decision on where it has been ordered. The occupational charge at the rate of the monthly rate paid. So the modification was allowed in a case. What is a better case? Millard. Then Millard, EIR 64. Ultimately, the modification was not allowed because Millard, after 2005-2025, this application for modification was done. That was a better footing.
Seeking modification from which effect? Effective from?
No, 2005 the order was there. The applicant said from the prayer is, my lord, it's a commercial place in High Court. Now, my lord, he further submits that the copies of the agreement substantiate 100 rupees per square feet. The property's question is justifiable. It is the contention to the monthly rating value at 1,48,200. And petitioner is appellant is paying only 454 per month. On that score, petitioner filed this application for modification of the order April 2005. The CAN number is, Miller, 2010. 2024. After 19 years. They filed after 10 years. And Miller, at the time of admission, there was no such order. But in this case, there was an order. Even then, Miller Court, considering the enhanced value, and it went up to the Supreme Court. Supreme Court did not interfere, directed the appeal court to hear out the appeal. And I will place the Supreme Court's order also. Supreme Court did not interfere.
As regards to modification.
Modification because at a belated stage. Belated stage, why I tell your lordship?
In respect of enhancement.
Enhancement, Miller, there was also, Miller, here the similar case, Miller, with regard to, Miller, suit for main profit that was there. Here, Miller, it has been denied. Denied. They did not pursue. Now, Miller, this judgment, the waiver, this is the last judgment. The waiver, paragraph 41. এই যে রিপোর্টের জাজমেন্ট এরকম করতে নেই, তোর তো সব জানা রে। কিছুই চাইছি না, প্রার্থনা করতে ঠাকুরের কাছে, তাই করছি। Waiver is an intentional relinquishment of a right. It involves conscious abandonment of an existing legal right, advantage, benefit, claim. Kindly sees claim. Kindly looks at Miller, looks into Miller, the legislature's word claim. Application is a claim. Section 3 says claim. Article 137 relates to application. Kindly sees, waiver is an intentional relinquishment of a right. It involves.
Referring to which paragraph?
Paragraph 41, Miller.
41. Yes.
Now, Miller, may I read? Waiver is an intentional relinquishment of a right. It involves conscious abandonment of an existing legal right, advantage, benefit, claim, or privilege, which except for such a waiver a party could have enjoyed. In fact, it is an agreement not to assert a right. There can be no waiver unless the person who is said to have waived is fully informed as to his rights with full knowledge about the son. It is not a case the party did not have the knowledge. It is not a case, Millard, that the parties, Millard, was not informed about his rights. Parties contested from 2003. So today, this is hopelessly barred. And Millard, it is a claim. I have relied. And Millard, 2007 also, Millard, while the court admitted the appeal, the court consciously did not grant any occupational charges. And first time, Miller, they filed the opposition, and 2017, after 10 years. Question is that whether the, Miller, if I conclude, Miller, I will not repeat what I have submitted. Possibly your lordship is not required to, Miller, hear it again, Miller. The last point which I would, Miller, persuade your lordship, Miller, every right
my lord. That's the just now I was arguing with the Honorable Chief Justice. But I know you need not use any microphone. Your voice is too loud. And I remember in one incident, sorry for deviations, I was arguing in court number 18, which Justice Mukul Mukherjee, Shri Justice Arun Datta, in the contempt matter. Learned Musi was really in trouble. He just made a representation to the division bench. I am really in distress. Their parties, they are not one of the parties violating, they wanted to show me some. Now, on the very next day, when I entered the room of court number 17, Justice Umesh Banerjee, as he was the class, Wait. Mr. Banerjee, Canada he has 2 cases at a time. In those days, no mic, nothing. Can a lawyer, a judge, he had 2 cases at a time? Come on, how can it be? Tell me frankly. I don't know. Yesterday that was happening. What is that? You are arguing code number 18 and wooden partition. So I just requested all the councils, please wait, let me hear Mr. Banerjee, and then I'll also hear him. And I'm sorry, my God. And one day, people just said, Bhagavati Banerjee, one young lawyer, said, my lord, he's shouting. How long you are practicing? That is normal for us. That's our problem.
That is gift of God.
My lord?
Gift of God. That is gift of God.
No, my lord, sometimes it's a problem. বড় চেঁচা but the people appreciate it. তুই আমার চোখ তো শুনি কি সব জাজমেন্ট দেখাচ্ছিস মাথা মধ্যে দূর এই যে
Yes, Mr. Basu.
অরিজিৎ প্রসাদ ভিক্টর জাজমেন্ট
আর স্মৃতির ভান্ডার থেকে আর কিছু বললে বলুন।
হ্যাঁ
স্মৃতির ভান্ডার থেকে আর কিছু বললে বলে দিন।
তখন তো তুই আমি যখন পুজো তখন তুই হাফ প্যান্ট পরিস তাহলে কি করে কি বলবো
না বললে তারা শিখতে পারবো।
শিকার বয়স তোর নেই
Millard, every right is coupled with duty, Millard. The duty, privilege, power, and immunity.
So as regards to limitation,
Limitation
completed.
Completed. Waiver, I have completed. And Millard, why it is waiver, I have read 41. Your lordship has to be satisfied that 41, Millard, it defines the contour when waiver comes. They had a full knowledge. They were conscious of their right. The court granted liberty. They did not. And Millard, it has a consequential effect. Millard, if the parties were not pursuing his right for damages of the premises, because mean profit is based on UJ's decree, it based on the damages I have used wrongfully after eviction, it starts from the date of eviction. So, when the party is with a full knowledge and fully informed and asserting his right every time, it means, Millard, he did not want to pursue. It leads to the path of abandonment. Now, Millard, what is the duty? Because duty is, Millard, that duty to act and duty to, Millard, because the judgment of the Supreme Court, at the cost of tiring repetition regarding, Millard, Article 137 applicability in a will, even if there is no legal obligation, the court can.
Need not be.
Yes. Section 3, Millard, it is incumbent upon your lordship. So the conduct says, Millard, today, and which he has, and regarding, Millard, the application, they have relied on certain agreement. And Millard, I did not have, Millard, the opportunity to, Millard, inquire, because, Millard, that is also not correct. And I have said in my opposition.
না করে বুঝে গেলি এই তুমি এনকোয়ারি করতে পারছিস আমার ইজ কারেক্ট না
বলছি my instruction is that this Millard, I have dealt it with, Millard, paragraph 6 of my opposition. And I have also said, Millard, that a plaintiff applicants filed a supplementary affidavit in connection with the said application in paragraph 9, annexing the rent receipt of Amita Ghoshal. It is categorically stated that no signature was found in the rent receipt in place of signature of the tenant. Therefore, such rent receipts are not acceptable in the eye of law. I said also, Millard, in paragraph 8, that the rent of a flat consisting of one room, kitchen, common veranda and preview situated at the opposite side of the suit premises has been fixed at rupees 1,200 per month. I have also, Millard, annexed here, Millard, the photocopy of the rent receipt in the same area, just opposite. But before that, Millard, your lordship may kindly satisfy your lordship's judicial conscience with regard to the application of the Limitation Act and the concept of waiver, and, Millard, abandonment of right to pursue, Millard, suit for main profit. When High Court, while admitting the second appeal, no prayer was even made, Millard, to pray for occupational charges. Sudden awakening from the deep slumber, Millard, whether it is clear. This is my submission.
Complete? So, Banerjee, only 2 points. First point, limitation with waiver. And the second point is as regards to the quantum. quantum you have heard?
No, my lord, this is not the first time that point is raised. Even the limitations, whether at all, can be realized or not. There's a judgment of Justice Purushottam Chatterjee. I am not going back to all these things, my lord. The father of Tom Chatterjee. Now, my lord, here limitation, question of limitation does not and cannot arise. Now, my lord, here is the statutory obligations you'll have to discharge, and whether I have claim or not, it is your responsibility to pay. It is not my responsibility to realize. Now, since you have failed to pay, naturally, now you'll have to pay on the basis of the court's order. My lord, judgment which is cited, unfortunately, doesn't apply. I'll just cite one Supreme Court judgment, my lord, which is very interesting. There is a judgment of Justice Arijit Prasad. What is the precedent? Because he's citing some judgment, that means he wants to show some precedents, this thing, that thing, limitations. First thing, this is not that act, it's a different act. Now, Justice Arijit Prasad very nicely dealt with the judgment. I'll cite it, I send it for that. Now, my lord, regarding other aspect, why did you not claim at the time of admission of appeal? Does it matter? Your Lordship's court, Justice Tandon, ওই judgment-টা তো দিয়েছে। দাও। না, জাজমেন্টে কপি দেওয়ার কোনো মানে নেই, পরে দেবে। শিখতে চাইলে তুমি পাবে। এটা একটু দিন তো ভাই। দেখবে না, শুনবে, শুনে শেখো, এই তো শিখতে চাইছিলে, আমি পড়ে নি তবে পাবে। Ability got this judgment, paragraph 6.
This one has not been referred earlier.
এদিকে আগে দেখানো হয়েছিল না?
Earlier, those judgments which were referred are 2017 to ICC 632 Calcutta, AIR 2005 Supreme Court 2457,
Is it precedent?
2024 SCC Online Calcutta 1178 on your behalf. 2005 1 SCC page 705, and the judgment passed in IA number 120219 of 2020 of the Honorable Apex Court.
So I'm reading, my lord, paragraph 6 of this judgment. In reply to the argument of my friend, I like him very much. He's a very brilliant lawyer.
Yes.
Paragraph 6. May I place it, my lord?
The condition of the
Yes. 2012 1 Calcutta High Court notes.
no,
I'm saying-
referring to 2015 for ICC.
কোনটা দিবে? এটা কপি আছে, কপি নেই? Just now you have handed over. দিয়েছো? 2012 1 CHN.
No, 2015.
এটা কোনটা?
2015 for ICC.
No, that is a different case.
Oh, এটা দাও, এটা। আরেকটু দাও না।
এইমাত্র দিলাম যে, কোথায় গেল?
এটাই দিয়েছো।
তো ওটা দিলে কেন? কি এটা?
এইটাতে প্যারাগ্রাফ
2012 1 CHN টা কোথায়? সেটা দাও না ঘরটা। এই তো, এটাই। 1 মিনিট মিলিয়ে নি, দাও, তাহলে জাজ সাহেবের কাছে আবার।
এইটা দাও এখানে। স্ট্যান্ডার্ড
হ্যাঁ, এটা তপন দত্ত তো জাজমেন্ট। এটা কার? I'm being half a minute time.
I think that I will get an opportunity to controvert his argument at the reply. Well,
answer to your judgment.
no, this is the because
Giving reply.
then she's giving a new judgment. I did not get it.
He's controverting your point as regards to
Yes, but
limitation.
allow me to distinguish, my lord. He's a senior member of the bar, my lord. I cannot match with him. Let me understand his.
না, অত বলে লাভ নেই, বসে পড়ো, তুমি পাবে না এখন, নতুন আইন করো না।
এখন ঠাকুরের কাছে প্রার্থনা জানাতে হয়, জানিস।
এইটা হচ্ছে জাস্টিস তপন ঠিক আছে, এটা দিয়ে দাও, তারপরে এটাতে প্যারাগ্রাফ 8 করবে, জাস্ট
দাঁড়াও এটার প্যারাগ্রাফ হচ্ছে 6
প্যারাগ্রাফ 6
My lord, kindly take note of it, my lord. 2012
2012
Calcutta High Court notes
1 CHN, yes, 1
Yes.
CHN,
1 CHN
Calcutta 247.
247 paragraph 6.
That I think is already there with you, Lord.
Is it there? একবার দেখুন যদি থাকে। নয়, আরে এটা দাও না, দিয়ে দিই, এত হচপচ করো, দাও, এবার যা সে বিরক্ত হবে, সেটা বার করে দাও।
এই চারটে দিন, এই চারটে আপনারা দিয়েছেন। Provided these 4 citations.
সঞ্জয় কাহলি, এগুলো দেখো, এগুলো হ্যাঁ,
These had been provided earlier.
এগুলো আরেকবার হোয়াটসঅ্যাপ বলছি, আরেকবার দেখে নাও। ইন দ্য মিন টাইম লেট আস রিড। একবার চেক করে নিয়েছো? ঠিক আছে, ওটা যা আছে। প্লিজ কাম টু প্যারাগ্রাফ 6 হচ্ছে
ওরালি বলা হয়েছিল কপি দিয়ে দাও এটা।
সাবমিট।
Yes, you are referring to paragraph 6.
Paragraph 6, my lord. Would you logically allow me to read, my lord? The learned advocate for the appellant petitioner submitted that when the learned lower appellate court had granted an interim order of stay, no prayer was made on behalf of the plaintiff respondent for imposing any condition for stay. He also submitted that when an interim order of stay was passed by this court, while admitting the appeal, no prayer for imposing any condition was made on behalf of the plaintiff respondent. According to the said learned counsel, the plaintiff respondent have waived, marked it, my lord. According to the counsel, they have waived their right to pray for imposition of any conditions. Such argument of the learned counsel for the appellant petitioner cannot be accepted. When the interim order was granted by this court, directions for filing of the affidavit were given, and it obviously implied that the plaintiff respondent could express their stay in the matter through the said affidavit. The plaintiff respondent have filed their affidavit in oppositions, wherein they have stated that they are entitled to the occupation charges in respect of the suit plat at the present market rate, even if they did not make a prayer for occupation charges from the making charges at the market rate in the learned first appellate court. They are not stopped from making any such prayer before the second appellate court as a condition for going to stay. Thus, the point of waiver of right raised on behalf of the appellate petitioner is unacceptable. Absolute bad on the point. Why that was done? But my case better than that. Here, even the lower appellate court is sought for any certain amount to be paid. Now, my lord, in appeal stage, High Court took trouble to say no. There's no question of waiver. Well, actually, that was decided by Justice Purushottam Chatterjee. There's no, it can't do that. He'll have to pay. There's no other alternative. And the case which has been cited by my friend, 2011-14 Supreme Court, ওরা দেখিয়েছে।
Yes.
This is a completely criminal case, a different aspect. This is criminal. Now, I'll just cite very interesting judgment, my lord, because I like this like anything. I'll leave it to see. Arjit Paswat is very witty. I had a privilege to appear before him in some cases. I'll draw your lordship's attention. Paragraph 13 onwards.
Citation.
Oh, citation. Yes. AIR 2008 Supreme Court 690. Have you got it, my dear friend? ওর একটু বয়স হয়েছে তো, ওর কানে কম শুনি। আচ্ছা, প্যারাগ্রাফ 13 বলুক না।
Yes, paragraph 13.
Yes, in words, in such and such case, Lord Reid said, Lord Atkins' speech is not treated as it fits for the statute definitions. It will require qualification in new circumstances. In such a case, one must not, of course, construe even a reserved judgment as such. Then there is always peril within every comma, my lord. Have you lost got it? There is always peril in treating the words of a speech or judgment as though they are words in a legislative enactment. And it is to be remembered that judicial utterances made in the setting of the facts of the particular case. Why I cited judgment of Justice Tapan Datta? Because a similar fact. Next paragraph. Circumstantial flexibility, because the cases which are cited to distinguish that, I am drawing logical additions. Circumstantial flexibility on additional or different facts may make a world of difference between conclusion in two cases. Disposal of cases by blindly placing reliance on a decision is not proper. That's why I say, my lord, what case he has cited? This is a criminal case, a completely different aspect, fact. Then, I am not yet finished. The following words of Lord Denning in the matter of applying precedents have become locus classicus. Each case depends on its own facts and close similarity between one case and another is not enough, because even a single significant details may alter the entire aspect. In deciding such cases, one should avoid the temptation to decide cases as led by Cotejo, by matching the color of one case against the color of another. To decide, therefore, on which sides of the line a case falls, the broad resemblance to another case is not at all decisive. Precedents should be followed only so far as it marks the path of justice, but you must cut the dead woods and trim off the side woods, else you'll find yourself lost in the thickets and branches. My please took up such. So, my lord, what I'm on, cases which are cited, it's a quite different aspect, different point, different case. And so far our case is concerned, my lord, especially the last case which I've handed over to Lord, absolutely the point which is raised by my friend, and the same point. A question of waiver does not consider here, then Attaram will go. What was happened in Attaram? That was happened in Supreme Court. No, he'll have to pay. Am I clear to you, my lord? Supreme Court Attaram Court says, forget about all these things. Now he'll have to pay at the market rate. Now, one very interesting, I've got other tenants. By filing an affidavit, he says, they are paying a meager amount. There is no suit against them. When I'll file the suit, I'll claim it. Now you are suffering and you'll have to pay. You are suffering.
How much amount have you claimed
Me?
per month?
We have given a chart. That was handed over to losses, my lord.
To supplementary.
Chart আমরা দিয়েছি একটা. Now, my lord, this is not the only case. Several cases now it is well settled. Everywhere, tenant is paying. Amount, yes, yes. আচ্ছা একটা chart. Supplementary.
In the original petition or the supplementary?
Supplementary. Yes, because that question raised at that time, might not inquire. কি ব্যা’পার করছে সাপ্লিমেন্টারি বার করো না সাপ্লিমেন্টারি if your lordships do not have this no
It is a calculation of unpaid occupational charges up to date 31/7/2022.
2023
up to 31st July 2022.
24 kindly see.
So you have mentioned that up to 31st July 2022, but in the chart you have given till
up to
July
date
2023.
up to date
21,000 per month
yes
at the rate of rupees 35 per square feet.
in that area is nothing.
This is your claim.
Total due is 25 lakh 22,000.
Anything more? Yes. Mr. Basu has not.
Oh, just standing judgment. কোথায় কোন জায়গাটা বলো তো হ্যাঁ কাটাকুটি নেই তো জাস্ট রেখে যাও দাঁড়া আগে ভালো নিজে চেক করুন 2015 4 ICC ওকে লিখতে হবে তো পেজ 17 এই দে তোরে, এই চ্যাম্পিয়ন ছিল, সুন্দর দেখতে, দিয়ে দে। প্যারাগ্রাফ 8,
ইউটিউব হচ্ছে আপনার কথা সারা ভারতবর্ষ শুনছে, বুঝলেন?
আরে শুনতে দে।
Which paragraph?
প্যারাগ্রাফ 8,
Paragraph 8.
8 onwards, my lord. May I place it, my lord? Paragraph 8. Have you got it, my lord?
This is the best copy.
এটাই কি পরিষ্কার? এই দাও তো একটা ভালো কপি আছে কিনা। আর ডোন্ট ডেট এবার ভালো কপি।
We shall hand over a fresh copy.
Yes, fresh
Just for
copy.
the time being, my lord.
Be kind enough to
Yes,
hand over
yes.
a fresh copy.
No, not kind enough, my lord. Somehow because of
আমি
long.
মহিলা বলে তাই বলেছি। Paragraph 8.
Hmm.
Admittedly, the judgment debtors opposite parties suffered a degree for eviction in the trial court. Since the appeal is a statutory right, the judgment debtor carried the said degree to an appellate court under section 96 of the Code of Civil Procedure. Order 41 to self-contained court regulating appeals. Order 41 Rule 5 of the court bestowed power of the appellate court to grant an order of stay as the persons who invoke the statutory right can be dispossessed or to suffer the consequences of the degree during pendency of the appeal. The blanket stay order not only deprives the degree holder to enjoy the fruits of degree, but in a way inures to the benefit of the judgment debtor to delay the execution case until disposal of the. The aforesaid points came to consideration with almost Supreme Court in case of Attaram. Then entire Attaram are also considered. Then paragraph 10, my lord. Have you got in paragraph 10? The ultimate conclusions of the Honorable Supreme Court in the said report has been summarized in paragraph 19 thereof, which is called to sum up while the passing an order out of Rule 541 of the Code of Civil Procedure, the appellate court does have jurisdiction to put the appellant on such reasonable terms as would be his own opinion, reasonable competence to the degree holder for loss occasioned by delay in execution of the degree so and forth. In case of premises governed by the provision of Delhi Rent Control Act, such and such, then other vacated premises. The ratio let them.
The amount which your client could have earned if they were not at that position.
If they are not at that positions.
If they were not possessing the said property at this present juncture, the amount of rent which your client could have.
My lord has gone to the root of this case.
Anything more?
No, if I let out now, because after all he is suffering a degree.
This judgment of Justice Govindu
Millard, only 3-4 submissions. Otherwise, Millard, I don't know, Millard, what is the, Millard, at least, Millard, give me a right of hearing 2 minutes. None of the judgments with deepest respect to the leading right of the bar, Millard, has considered, Justice Samanto's judgment coordinate bench has considered Attaram. There, Millard, also order of occupational charge was there. From Justice Chandan to Justice Atmaram, Millard, this particular aspect, this particular Millard, I know Millard what he is saying. What he could have done, Millard, possibly your lordship is not of the opinion that the division bench, while granting Millard the stay order, framed the question of law. The division bench was not well aware of the law. Division bench was conscious. The parties, Millard, and none of the, in this judgment, series of judgment which you have given, kindly ask him, the learned senior friend, he's a very respectable man, Millard, that whether he has given that this point of limitation was ever raised and argued and considered. Justice Samanto has considered. What he could have earned, Millard, I am not getting a charity from the division bench while granting the order. It's a question of law that has been framed. It is he did not pursue the appeal. It is he did not pursue, Millard, the suit for main profit. What he could have achieved, Millard, that is a question, Millard, academic exercise. But the question is what he could have done also, that part also, Millard, that what he has done for asserting his right when the right is with him. If that he has not done, whether section 3, 137, application claim, all these points, and he is talking about, Millard, very lightly and innuendo. I do not know whether your lordship has taken this very seriously or lightly, that he said page 41 is a criminal matter. 41 is a principle of law. Article 141 judgment applies to all.
After all, Mr. Basu, it does not bar his client from claiming.
No. Then Millard, Section 3 of the Limitation Act, whether this has been considered or not.
It will be gone through, it will be dealt with. It will be dealt with.
Yes.
The order it will
And
be
Millard, 41, he says, Millard, that, and 21, what is the basis? These are guise of eviction. Kindly, Millard, deal with this. And 41 is not a criminal matter. It is a law laid down by the Supreme Court, even if it is a criminal case. He was conscious of his right, asserted his right, my lord. I know, Millard, that it is very difficult because, Millard, to combat with this confusion, because, Millard, I am very helpless because none of the judgments has ever, Millard, considered the point of limitation, and he passionately relied on that and tried to persuade your lordship when, Millard, admittedly this point was not considered, because I expected to learn something from my senior friend, that he must address the issue and enlighten us that the point of limitation is irrelevant and does not apply. This point of no, it is not. I did not.
heard.
I'm sorry, Millard, if I bothered you, lordship.
Heard knowledge council. Heard,
But I'm a very poor middle class tenant, Millard, at least also considered.
तुम जो judgment টা দেখেছো যে তোমার
Mr. Basu,
করেছে section 3
Senior counsel,
Middle class tenant.
representing
fine
the
industrial district.
And one of my clients is suffering from cancer also, Millard. Kindly also.
No, this is unfortunate.
Telegraph, section 10 of telegraph.
appellant tenant, elaborately. Full stop. He has completed his submission. Full stop. Mr. Banerjee, the senior counsel. He is replying to the same. Full stop. Hearing is concluded. For orders.
I'm sorry, Millard. বন্ধ করো।
Order.
Order.
Application can 2 of 2007. Can 2 of 2007.
আমার কাছে তো
Can এর order. এটা ল্যান্ডলর্ড, ঠিক আছে, এটা ল্যান্ডলর্ড আর এটা টেনেন্ট।
কপিটা দিয়ে ওটা
ডাক দেয়া কবিটা নিয়ে চলে গেল।
এগুলো তো
না
আপনার
না কপিটা দিয়ে ওটা
আমার কাছে নেই বাবা।
আরে ওটাকে দেখে আনতে হবে
আমার
তো।
চলে গেল অশোকদার ফাইলে
ডাকো। Item number 2.
Item number 2, Millard, can kindly take it up next Friday. My lord will be sitting, Millard. Now, Millard, I hope regularly. Millard, I am ready with the matter, Millard.
And your lordship sitting single very
What happened, Millard?
It was earlier on the last Friday only.
Millard, what happened, Millard? Millard, my clerk has gone to his native house, Millard, for this SIR, Millard. My books and other things, Millard.
appearing in the list
Yes,
marked
Yes, my lord.
Today's
I am
date is
handicapped
16.
today, my lord. Lordship will be kind
Today's
enough to
date is
take up
16.
next Friday, my lord. Otherwise, I am ready with
Yeah,
I'll
you
come.
know, on Saturday.
Lordship kind enough to take it next Friday or any day, my lord. I'll be ready. I am ready, my lord.
My
Today.
lord, your lordship sitting, my lord, is
He's saying that he's handicapped because something has the learned council represent.
I did his argument earlier. Every day, every day.
কবে থেকে লিস্টে আসে বলতে কবে থেকে
We are hearing the second appeal.
Definitely.
Yes.
No applications.
No applications. pending.
Appeal.
Appeal itself.
28.
I'll not take it.
Your lordship will be sitting every Friday, as we learned from the list.
নেক্সট ফ্রাইডে Lord, in item number 3, my lord, I will look the appellant in this matter. Now, my lord will recall there are 5 applications that are pending before your lordship.
5 applications.
Can I'll just authentically, my lord, indicate what's there in this matter, my lord. Can 1 is the, my lord, the application under section 5, my lord, in filing the delay in filing the appeal. 42 days delay, my lord, it's there in can 1. Can 2, my lord, is the stay application. My lord, can 3 is lordship the substitution application where the applicants have filed after the death of the appellant. Can 5, my lord, is the application praying for setting aside of abatement, and can 6, my lord, for condonation of delay in preparing the substitution application. These are the 5 applications.
How many days delay in filing the substitution application?
My lord, in my application, there's a delay of 1,200 days delay, my lord.
Learned council, have you received copy of the applications?
Yes, my lord, pleadings are complete, your lordship. They have filed their objection.
Affidavit of opposition filed.
Yes. My lord, apart from the COVID
Can
period,
6.
can
Can
6 is my
Can
application.
6 the application for under section 5 for conditional delay.
If the, my lord, the COVID
1
period,
minute, 1 minute. Yes, can 6.
yes, my lord will take page 10. My reliefs are there, my lord. Delay of 1,229 days of delay, my lord, in preparing the application. My lord, I'll also indicate when the,
Paragraph.
my lord, paragraph 27, my lord, my pleadings.
Due to reasons stated above.
Yes, my lord. I'll
Where are the reasons?
please, my lord. Kindly allows me. My lord, the paragraph starts from. Also, my lord, kindly notes at page number 14, the death certificate is annexed of the original appellant who died on 5th September 2020. My lord has got.
during
The
the
paragraph
ongoing
number?
pandemic.
Oh.
Page 14.
Page 14, yes,
Yeah.
page 14.
During the ongoing pandemic, my lord. Yes.
5/9/2020.
Yes, my lord. 5th
Hmm.
September 2020.
Hmm.
My lord, from paragraph 6, my lord, my reasons are there.
Gulambari Mondol.
Gulambari Molla, my lord. Mondol.
Mondol.
Appellant.
Hmm.
Appellant.
Yes.
So, my lord, I'll also indicate, my lord, in the COVID period, the suo moto, the suo moto case that was pending, my lord, that was passed, my lord, by the Honorable Supreme Court. If that period is, my lord, calculated, then the days comes to 600, my lord, 85 days. I'll demonstrate that during my course of submission. Now, my lord, from paragraph 6, my lord, the reasons are there. If I may humbly rely on those, my lord. The applicant state that the onset of pandemic from March 2020. Your lordship will kindly come to page number, my lord. First, my lord, kindly comes to page number 12 once. This is when the appeal, my lord, first appeared before your lordship, where it was observed that due to delay, the can is pending. Therefore, it has to be delisted from the division bench. Thereafter, my lord, kindly comes to page number 13. Section 5 was appearing before the Honorable Single Judge. The petitioner is directed to serve a copy of the Section 5 application. Thereafter, my lord, can you also note the date? The kindly note, my lord, this is the order of 15th January 2020, page 13. And thereafter, my lord, from March, the pandemic, my lord, started. And I placed my pleadings from paragraph 6 onwards. The applicant state that the onset of pandemic from March 2020, followed by the nationwide lockdown, the original applicant lost the track of this instant matter pending before the Honorable High Court. Thereafter, my lord, I have mentioned the date of death. During the COVID, the applicant passed away on 5th September.
Thereafter.
Yes. It is stated that the applicants were unaware of the pendency of this instant appeal before the Honorable High Court, since the original appellant
Who are the applicants?
The applicants are the legal heirs of the, my lord, the wife,
Means legal heirs means
wife, son, and daughter of
wife,
the
son, and daughter.
Yes.
Son, aged
aged around, my lord, 44 years at the time of appeal. It appeared from the
44 as on 2024.
Yes, my lord.
So 40 years at the time of death of his father.
Since the father was already looking after all the matters, my lord, he was not aware of the ongoing proceedings before this honorable court, and also the other, my lord, litigations that's pending, my lord, before the other forums. My lord, therefore, various critical informations regarding the pending litigations disputes were unknown to the applicants due to the sudden demise of the original applicant.
Suit for?
My lord, suit for, my lord, for declaration that the deed of sale is yes. Even the defendant we lost, but my lord, we are still in possession of the property. My lord,
Deed of sale. Who was the vendor?
the respondent is the vendor. He sold the property to the appellant. He's my brother. The respondent is my brother. He sold the property to me. Well, from
Anything more to be submitted?
well, from paragraph 9, what has happened is, lordship, we were running from pillar to post from advocates. Well, they are, if I may use this, they are not very educated in this, my lord, matter, my lord.
Who are not educated?
My lord,
Who were or who are not
they are all
educated?
cultivators, my lord. They are all, my lord, they are unaware of the facts and circumstances.
Whose property is in?
My lord, it is in
Situated at
North Chobish Pargona, my lord, in village Maguruti. Maguruti. Maguruti, my lord. My lord, I've also mentioned he's a farmer, my lord. He is not aware of the details of the matter. My lord, therefore, my lord, he was running from pillar to post. If I may succinctly say this, he was running from pillar to post and was not advised properly. If I may. Thereafter, my lord, the no objection was received, and thereafter, my lord, from the erstwhile advocate, and thereafter, my lord, they have approached the current advocates, and accordingly, my lord, the applications were filed.
let the advocate be informed.
My lord,
Let the advocate be intimated that an affidavit be filed by the advocate, learned advocate. The same story crops up in each and every case. Let the advocate be intimated to
kindly-
file an
my lord,
affidavit.
But she is not in practice anymore, my lord. This is
And
what I
now,
want
now all the things are coming out.
to practice anymore.
Let the learned advocate be intimated to file an affidavit.
My
To
lord,
that
kindly,
effect.
kindly doesn't direct that. That will
That will be the order.
requesting your lordship. This will, my lord. She is not.
The self-same old story should not continue day in and day out.
There was problems, my lord, from our end as well, my lord.
Blaming. Yes, the counsel.
Appellant died in the year 2020,
2020.
September
5th of
2020.
September 2020.
And according to the appellant to the applicants, they came to know the existence of appeal in the month of March 2022. But it was not accepted because, my lord, it is a continuing for 2007, cities of 2007. And secondly, my lord,
Trial court.
My lord,
In the trial court, what happened?
trial court, my lord, we lost.
First appellate court.
both the questions, judgment of affirmation. And the knowledge is in the year 2000, March 2020, but the application was filed in this application was filed in 26th of April 2020. You can see the paragraph number 16 at page 7. First ground is that they have no knowledge about the existence of appeal and they came to know in the year in the month of March 2020. And in secondly, paragraph number 16.
Paragraph number 16.
16. Let the towards middle. The applicants state that since this instant matter was out of list for a long period of time, the learned advocate tried to mention the matter before the honorable bench, taking up the hearing of second appeal to seek the leave of the honorable court to make appropriate application for substituting. Is there any leave required, madam? This is a lame excuse. This isn't the excuse. Is there any leave required for filing any application for substitution? It is the duty of the applicant to file the upon the death of the applicant to file application within a certain time. There is no leave is required. And there is also in this second paragraph also present that the after getting the leave of the honorable court, they file the vokalatma, praise vokalatma. In filing the vokalatma, no leave is required. Paragraph number 9. Paragraph number 9. Finally got
Subject to correction, my lord, it's recorded.
No, leave was granted, but no leave is required for filing any application or any vokalatma. So all the grounds taken for application for connection to get accepted. They came to their knowledge in past 2023. The year 4 months 2 weeks.
And delay in filing the appeal?
45 days.
45 days.
That was filed in the year 2019.
But if I may put these two judgments regarding condonation of delay, my lord, it should be. I leave it up.
How many? How many citations?
Two sides.
Only two.
Mm.
Mm. The Senate Council representing the appellant, okay, proposed appellants. It was a Can 6 of 2024.
Sir, my lord, only problem is this, my lord. I consider an interim order, my lord, till the disposal of this appeal. With an hope and expectation, the appeal will be taken up for hearing. My lord, they are enjoying the interim order. And, kindly fix a date, my lord. Here's it.
Yes.
This short point, my lord.
My lord,
The application of, my lord,
I am praying for not today
benefit
only because on behalf of Mr. Rabindranath Dotto, his personal difficulty.
ठीक है. The short point, my lord, judgment of reversal, my lord. I am the plaintiff. My lord, trial court will not dismiss the suit, my lord, appellate court will not decree the same. Absolute suit for declaration that I am the owner. I am the owner of the property in question. I mean, they also claiming their ownership through somebody else. Now, my lord, ultimately, my lord, trial court will not dismiss the suit. Appeal court will not decree the suit, declaring my rightful interest. My lord, trial court, my lord, with the greatest of respect, my lord, trial court, my lord, did not understand the, my lord, provisions of the, my lord, Benami Transaction Prohibitions Act. My lord, wrongly applied the same, my lord, dismiss the suit. My lord, a short point, my lord, whether this act, my lord, applies or not. Appeal court held, my lord, this act does not apply at all. The property was transferred in the year 1981, when this act, my lord, was not there also. This act is 1988, 88, and the property was transferred in the year 1981. But kindly fix, my lord, and I will not take, my lord, more than half an hour.
Only for not today, my lord. Only for Monday, matter will be heard.
28, my lord. Let it
28.
appear, my lord, at the top, my lord.
hold up after a long time.
What can be done, Lord? This is my Lordship's bench is not regular.
From now on onwards, hopefully it will be regular
Yes,
on Fridays.
on Fridays. No, Lordship knows not the second appeal, my Lord. It is your Lordship will hear someday. Thereafter, your Lordship will forget.
No, can I-
Given other determination.
from now onwards, it will be taken up on Fridays.
All right.
May I start? My learned senior will start today.
না না আপনার বলা হয়ে গেছে তো
হ্যাঁ।
জয়সাব যদি রিকভারি ইউনিট করতে হয় করে নিন, নাহলে আমি বললে আর আপনি কি করবেন?
আমার রিপ্লাই দেওয়ার সুযোগ আছে।
রিপ্লাই দেওয়ার ফ্যাকচুয়াল অ্যাসপেক্ট দেওয়া হবে না। আপনার যদি বলতে হয় জয়সাবকে মনে করিয়ে দিন, তারপর আমি বলে দিই।
No, Mr.
Whatever
Ghosh,
George, whatever my lord will direct me.
Mr. Ghosh, you
Yes.
start,
এবার
then
নোটগুলো বের করুন।
বই আছে না? Appearing in the item as item number 7. So there has been some mistake. That should have appeared as item number 4.
Release after recess.
Huh? Till recess,
Yes.
Mr. Ghosh obviously will continue.
Yes,
Thereafter, we don't.
Lord, after two, my Lord, I have some difficulty because Division Bench Justice Bosak and my Lord Justice Ajay Kumar Mukherjee.
Let us
I will not be here.
let us
Your Lordship kindly take.
2 p.m. The paper book.
Kindly take the paper. Lord, initially the suit was filed by the respondents before your Lordship for declaration and injunction. Lord, their case was that they purchased the property from one Satkori. And Lord, there was before purchase, there was a partition, registered partition deed between Satkori and Panchkori, two brothers. So for Panchkori is concerned, Lord, he sold two separate dags in favor of the predecessor in interest of my learned friend, learned friend's client. Lord, your Lordship, from the deed itself, it will appear that Panchkori has no concern with the dag number which my client purchased from Satkori. But Lord, subsequently they interfered with our possession. That's why we filed the suit. Lord, this is basic thing, Lord. He has not basically, they have no title. However, after filing of the suit, Lord, it is from the deed I place before your Lordship, it is clear that they have no right title interest in respect of the dag number which my clients purchased from Satkori.
Documents, document. Deed of sale.
Lord, your Lordship, kindly take first the deed of partition.
Mr. Ghosh, can we go through the compilation?
Yes, that
Compilation
will get
subject.
Deed
Acha,
of partition.
and during the Mr. Ghosh, during the course of this day, let your junior be there go through the documents, whether all the documents are there or not.
Yes. Lord, those are exhibited. Not, yes.
Till now it is there or not, otherwise
Yes.
complications will arise. So you are referring to
Lord, your lordship, take both the compilations, one submitted by the other side and Lord, one submitted by us. Your lordship, so far partition deed is concerned, your lordship will get it from their compilation, item number 6.
their compilation, item number 6.
Yes. At page 124.
Yes.
Lordship got it. Lord, here your lordship kindly see the just placing Lord the recital first that such and such নিম্নে তফসিলে যায় ক তফসিল সম্পত্তির মূল্য 34,000 টাকা 34,000 ও তফসিল খ তফসিল সম্পত্তির মূল্য 34,000 টাকা প্রথম পক্ষ 5 কোটি পাল পিতা শিবনারায়ণ পাল জাতি হিন্দু such and such and দ্বিতীয় পক্ষ 7 কোটি পাল Lord, the lordship as I stated. Now what happened, Lord? They have given Lord what is the allotment of 5 kodi and 7 kodi. Your lordship will get the allotment of 5 kodi. My lord, kindly come. Yes. Your lordship, relevant property, your lordship will get it at page 136. Page 136.
136.
There. Lord, your lordship will get in the middle this terror ক তফসিল সম্পত্তি. Lord, I'll get middle. 1, 2, 3, 4, 5, 6. Lord, 7th line. Lord, 7th line from bottom.
13 ক তফসিল সম্পত্তি যাহা
প্রথম পক্ষ 5 কোটি পালের অংশে যাতে 16 উক্ত খড়ার মৌজায় খাস দখলি মধ্যসত্ত্ব নিষ্কর 112 নম্বর খতিয়ানে 57 পুষ্করিণী জল মাই পাওয়ার পরীক্ষাদি নিজ রকম 67 পুষ্করিণী এত একর তারপর এবং 67 and now this is the allotment. Lord, your lordship, kindly come to next page 137 at the bottom. These are the relevant suit property, Lord. That's why I'm pointing. There are so many properties. These are the suit property. Lord, your lordship will get at the bottom 2, 3, 4, 5.
এটা সুট প্রপার্টি নয়, এটা নজর প্রপার্টি।
এই তো 1090। হ্যাঁ 1090 ওরা কিনেছে।
হ্যাঁ ওরা
তাই তো বলছি ওদের প্রাপ্য। Lord, kindly see this allotment, this allotment 18 উক্ত খড়ার মৌজায় 18.
Lord, may I have your lordship's kindly.
Yes. Lord, যাহা প্রথম পক্ষ 5 কোটি পালের অংশগত উক্ত খড়ার মৌজায় 365 নম্বর রায়স্থিতিমান খতিয়ানে 1843 দাগে বাস্তু 25 শতক মধ্যে 1835 দাগে 24 শতক 2264 দাগে বাস্তু 44 শতক মধ্যে অর্ধাংশ 22 শতক. Lord, kindly this is relevant. It will appear that it has been sold to the other side. The 1090 1090 দাগে বাস্তু 37 শতক 2151 দাগে 3254 2151 বাটা 32 শতক 54 দাগে বাস্তু 24 শতক মধ্যে উত্তর তরফে 12 শতক 120 শতক খাজনা সাচান সাজ সাতকড়ি পাল সাচান সাজ তফসিল সম্পত্তি যাহা প্রথম পক্ষ 5 কড়ি পালের অংশগত উক্ত খোড়ার মৌজায় গ্লোরিয়াস 1842 1842 ও 1843 দাগের উপরিস্থিত উত্তর দক্ষিণে লম্বা করগেটেড পার্টিশন বিশিষ্ট উত্তর পূর্ব দ্বারে 1 কুঠুরি ও পূর্বদারি 3 কুঠুরি পোক্তা একতলা গৃহমূল্য 4000 টাকা 1097 দাগের উপস্থিত পশ্চিম ও দক্ষিণ দারি 4 কামরা পোক্তা গৃহময় হল ও সংলগ্ন দক্ষিণ দিকে করগেটেড ছাদন বিশিষ্ট সীতাবেড়ার দেয়াল মাইকূপ ও পায়খানা সহ 3000 টাকা। না 1090 দাগে দক্ষিণ দারি নিচে উপর 2 কুঠরি পোক্তা গৃহময় তল ও বারান্দা সহ ও পশ্চাৎ দিকে মাটির দেয়াল করগেটেড ছাদন বিশিষ্ট প্রাচীর বেষ্টিত গৃহাদির মূল্য সাচান সাজ 1835 দাগের উত্তরদারি করগেটেড ছাদন বিশিষ্ট মাটির দেয়াল 2 কুঠুরি ঘর মাই পশ্চাৎ দিকে চালা সহ 1000 টাকা মূল্যের সাচান সাজ। Now, Lord, this is the allotment. Lord, this is relevant in view of the fact. Lord, in fact, this Panchkodi has sold this property to the other side. So far, our property allotment is concerned, which is a Batadag, that has no concern with their deed. That's why I'm pointing out what was their allotment so far this Vastu property is concerned. Now, your lordship kindly come to our allotment, our predecessor's allotment. I'm showing from their deed that what they have sold. Lord, your lordship kindly come to page 149 of that compilation. Lord, your lordship kindly mark it. Your lordship will get 147. It's দ্বিতীয় পক্ষ মিডল 23 সম্পত্তি যাহা দ্বিতীয় পক্ষ 7 কোটি পালের অংশগত। Your lordship got it? Yes. In middle, that's why I'm indicating that 7 kodi, it is under 7 kodi is there. It starts now. Relevant page is not page 148.
148.
Yes.
148.
Yes. Lord, from 1, 2, 3, 4, 5th line, 4th line, Lord. This is from top. I'm reading that জল 12 শতক 82 থেকে জল 57 শতক বাস্তু 2264 থেকে বাস্তু 44 শতক মধ্যে 22 শতক 1987 দাগে বাস্তু 16 শতক 1085 বাই 2969 1025 বাটা 2969 দাগে 17 শতক 2151 3154 বাটা 24 শতক মধ্যে দক্ষিণ তরফে 12 শতক। Lord, this is relevant. This property is the suit property 1085 by 2969. Now, Lord, kindly see their deed of the deed transferring by which the Panchkodi has sold to some Renuka. Lord, your lordship now take our compilation. That is not page 1 to 6.
1 to 6.
Yes.
Schedule.
Schedule. State MLO come to schedule. Your lordship schedule starts at page 5. জেলা মেদিনীপুর থানা ও সাব রেজিস্ট্রি ঘাটাল পরগনা বর্দার অন্তর্গত 44 নম্বর থানা 163 নম্বর তৌজি মহল বর্দা খড়ার মিউনিসিপ্যালিটি ভুক্ত খড়ার মৌজায় 365 নম্বর রায়ত স্থিতিবান খতিয়ানে 1090 দাগে বাস্তু 37 শতমিক খাজনা সাচান সাজ মূল্য সাচান সাজ and whatever it may be উপরিস্থ বাস্তুর উপর সাচান সাজ construction. Not relevant is this dag number
1090
and 1085.
1085.
Lord, there is nothing. Your lordship kindly see, this is very important because apart from this, they cannot claim anything. It is their deed. Now, Lord, kindly take our deed by which we have purchased. That is by Satkodi, 7 to 15. Lord 7 to 15.
Yes.
Lord, this is the Lord key point here. If your Lordship consider this, everything will be solved. Then what they have done, how fraud has been practiced by the court and the parties also.
By the?
Huh?
By the?
By them.
By them.
Lord, kindly come to page 14. এটা কার বাস্তু এই তো কপি দিয়েছি হ্যাঁ এখানে কে দিচ্ছে কে হিন্দু কাইন্ডলি সি at page 7 this is Dilip Kumar Datto পিতা বংশীবদন and Sandeep Kumar Datto পিতা রামকৃষ্ণ দত্ত and Bikretam Lord Satkori Pal. Lord the other brother other allotee. Now your lordship kindly see the schedule. Lord, I have shown Lord his allotment. This is the Batadag 1085 by 2969. Your lordship now kindly come to this schedule. Such 1090 বাস্তু 37 শতক ও 1025. Lord, it is part. Your lordship kindly see 1090 দাগে 37 শতমিক ও 1085 1969 দাগে বাটা দাগে 17 একুনে 25. Therefore, Lord, so far this dag is concerned 1085 1969. Lord, they have no relation, not at all.
So how could they sell this one?
Huh?
So how could they sell this one?
They didn't sell, Lord. That's why, Lord, this is not there in the schedule in favor of Renuka. Is not there. What happened now? Lord, here your lordship kindly notice 1090.
But from this deed, wherein the vendor is Satkori Pal,
Yes.
The purchasers are Dilip Kumar Datto and Bongshibodon Datto.
No, Dilip Kumar and Sandeep. Bongshibodon is father.
Oh, sorry. Dilip Kumar Datto and Sandeep Kumar Datto.
Yes.
In the schedule mentioned there are 1090 and
Lord, that is part of their 1090.
Their property.
Yes.
And the
So far,
second
Lord,
one,
this dag is concerned. It is absolutely. They have no share. They have not mentioned in their deed. Satkori, Pachkori has got no allotment in this. It is absolutely, Lord, 17 decimals or 17 satomik, whatever it may be. This area has been absolutely given to us.
that
Now,
is
Lord,
Satkori.
yes, Lord, but as the properties are adjacent, taking advantage of that, they started interfering with our possession.
Okay.
Accordingly, we filed the suit. Now, Lord, kindly see the list of dates. How they have done. Court's proceeding. Lord, we filed the suit. কবে ফাইল করলাম নি? সুটটা ফাইল করলাম আমরা কবে? তার একটা লিস্ট অফ ডেট আছে। Yes. Lord, we filed the suit. Can you take the list of date, Lord? September, 2000.
List of dates is
Lord,
given in
Lord, we have given,
compilation.
not in compilation,
Separately.
এটা আমরা দিয়েছি না, এটা তো ওদের, আমাদেরটা বের করুন। ওরা এখানে দেবে না, বের করুন না কেন? আমার ফাইল করি, আমি কালকে রাত্রে হলে বের করে দেখি। ওরা দিয়েছে আমরা দিচ্ছি, আপনি কি দেখুন না আমাদেরটা করে
First appeal.
My lord, earlier occasion. Yes. এটা আমাদের during hearing earlier occasion it was given to your lordship. If it is not নেই, আমার কাছে আরেকটা কপি আছে, দেখুন আপনার ফাইলে আছে নাকি? তোমার কাছে আছে একটা কপি? আমরা যেটা দিয়েছি এটা আমাদেরটা আছে দিয়েছি তো কপি। আপনার I am placing. Lord, Lord, your lordship, kindly take the dates. Take note of the dates. Lord, your lordship has already taken note. Your lordship has not taken notes of the dates. Lord, your lordship, kindly see the partition deed was of deed of partition. Giving the date. That is the Bonton Nama. Bonton Nama date টা কবে? Bonton Nama date লেখেননি? 60. Yes. Lord, your lordship, kindly take the date of the partition date. That is 9th March 1960.
9th March
1960.
60.
60. Now, Lord, the Pachkod is sold to the predecessor in interest of the appellant before your lordship on 13th May 1961.
13th May
Yes.
1961.
Yes.
So just
Correct.
after
After partition. Got it?
Yes, list of dates.
Yes. ওটা কি আমাদেরটা নাকি দুটো আছে কিন্তু
Oh.
দুটো লিস্ট অফ ডেট লর্ড আইটেম সিরিয়াল 2 13 May 61 পাঁচকড়ি পাল সোল্ড 13 decimal land to শ্রীমতী রেণুকা চৌধুরী
13th May 1961. Pachkori sold
Yeah.
0.037 decimals of land to Srimati Renuka Rani Chaudhuri by a registered deed of sale in plot number 1090 and also in plot number 1085.
Therefore,
There is no whisper in the said deed of sale regarding the suit plot number 1085 by 2969.
yes, being the number such and such. Lord, it is now clear, Lord, that what I was pointing out, it has been clearly mentioned in the list of date.
Achha, there's a separate list of date filed by them also.
Filed by them.
Why there's a separate one?
Lord, they have prepared according to their.
How can list of dates differ?
Lord, they have not given all the relevant dates.
Achha.
According to their convenience,
Achha.
they have given it.
Achha. But
Lord, your lordship,
we could find this one
Lord,
only.
from their list of date, all Lord, the relevant dates will appear. Lord, regarding partition deed, then Pachkodi Pulse transfer, Satkodi Pulse transfer. Also, Lord, kindly take my list of date. I am placing it. Now, Lord, Satkodi Pal. Your lordship, kindly come to Satkodi Pal, item 3.
1 minute.
It is in our favor. Satkodi.
Item 3, yes.
Lord, kindly remember, Lord, Pachkodi is their vendor
Their
and
vendor.
Satkodi is our vendor. Lord, this Satkodi sold, Lord, this is the suit property. Your lordship, kindly see this Bata plot 1085 by 2969 along with other portions in favor of minor Dilip Kumar Datta and minor Sanjeev Kumar Datta by registered deed of conveyance dated such and such 30th May 1969.
1969.
Long after their transfer, Lord, kindly note. Now, it is between the plaintiffs, that was a deed of family settlement. Lord, so far their purchase property, it has got no concern with others. Now, Lord, kindly see. This item number 5, your lordship, kindly. Lord, 4 is in between us.
So you have sold later on.
No, we have not sold. Lord, we are Sandeep or Dilip.
No.
Satkodi sold later on.
Satkori sold later.
Satkodi in our favor.
In your favor.
Lord, thereafter, Lord, we made an arrangement.
You have purchased later on
Yes.
30th May
Yes.
1969.
Yes. Thereafter, Lord, we made a family arrangement regarding ourselves. That is not
between yourselves. They are
that has no concern. Now, your lordship, kindly see that Pachkodi is purchaser. See again transferred to in their favor. Pachkodi is purchaser. Lord, item number 5. Here also, my lord, kindly see.
Renuka Rani Chaudhuri.
Yes. Renuka Rani Chaudhuri executed. Lord, this is 1999.
Yes.
Your Lordship, this Srimati Renuka Rani Chaudhuri executed the alleged deed of sale in respect of 8 decimals of land in suit plot number 1085 by 2969.
Hmm.
Though Lord Renuka had no right title interest in respect of this Bata plot. Lord, your Lordship has noticed it. In favor of defendant, respondent, appellant number 2, sale deed number such and such, 29th October. Lord, basically, when she has no right title interest, she has not acquired any right title interest, how can so? This is one of the questions. Now, your Lordship, kindly see, the plaintiff's appellant respondents filed titles number 133 of 2001 before the trial court. Lord, this is the suit out of which the appeal has come before your Lordship. Lord, trouble started here. Lord, we filed a suit when they came to interfere with our poison. Now, Lord, kindly see the conduct. Here is the fraud started. Lord, we filed this.
So the fraud cropped up on 29th October 1999
first.
By the sale of a part of
Our
0.008 decimal of land in suit plot number 1085 by 2969.
Yes.
By Srimati Renuka Rani Chaudhuri, who purchased from Pachkori.
My Lord, is clear. This is now clear. Now, Lord, we filed this suit when they started interfere on this basis in 2000. Your Lordship, kindly see this suit was filed, Lord, here given in 8A. Because it is necessary, I am pointing out first. January 6, 2001, suit was filed.
Which suit was filed?
No, this present suit number 133 of 2001.
No, 133 of 2000.
133 of 2000.
133 of 2000.
Yes. 133 of 2000. Plaintiffs filed the suit for declaration and injunction. Now, Lord, kindly see, 14th September, suit was filed. 14th September 2000.
14th September 2000.
Lord, after service of summons, they didn't enter appearance. Took time, one after another. In the meantime, Lord, kindly, January 6, 2001, they filed another suit.
January 6, 2001.
Yes.
It is not mentioned in the list of dates.
No, I'm not. I'm here. I'm pointing. Lord, this suit, after filing of this suit, Lord, the another suit was filed for declaration to the effect that there was that mistake was that in 1999 there was some mistake and they sought for a declaration and managed the decree ex parte. That suit was not filed against us, but in between the vendor and purchaser. Well, I give the details. Well, I am for the typing.
You were not made a party in that.
No. No, that will appear
from the suit of 2001.
2001.
What was the prayer?
Prayer, Lord, that deed rectification of the deed.
Rectification of the deed in respect of
this was respect of the 99 deed. In this 60 deed.
Wherein they had sought for?
In the same court?
No, wherein means not in the court. Wherein they had sought for rectification of?
Rectification of the deed.
Number.
Oh, deed.
That number.
Oh, the number, Lord, this is for inclusion 1085. Also, they have purchased, sought for declaration and got a managed and ex parte degree behind our back. Thereafter, entered appearance and filed this instrument that by rectification, this has been also introduced in the original deed.
So, through the title suit filed during the year 2001, they had sought for amendment of the deed executed during the year 1999.
Yes.
Seeking implement of
this Bata.
Dag number 1085
By
by 2969.
Yes. My lord, I shall the place before your lordship the plaint, your lordship, everything would be clear. Now what happened, lord? Yes. Yes. Lord, your lordship, can you see? I am stating suit was filed. Bereft of unnecessary details, the petitioner's case is that the present plaintiff has filed the instant suit in respect of plot number 1090 and 1085 by 2969, taking the plea of misstatement of the in the Kobala. Originally, the suit property belonged to Satkoripal and Pachkoripal. Here also detail. They are held a partition deed amongst those Satkori and Pachkoripal on 9360, and by dint of that partition deed, the entire plot number 1085 2969 by 2969 and plot number 1099 on its western portion, the entire the Satkoripal got it. Pachkori had no interest therein. On 30th May 1969, that Satkori sold out the entire 1085 of 2969 and his possession portion of plot number 1099 by dint of Kovala, and the present petitioner got the property, and their names have been recorded in respect of these plots. The present plaintiff in the instant suit has purchased some portion of from dag number 1090 from the defendants, wherein the plaintiffs did not acquire any right, title, interest, but they have threatened the petitioners, and present petitioners have filed titles number 133 against the.
Mr. Ghosh, go through the prayer portion once.
No, this is not the judgment. I'm saying the titles. Yes. এটা তো আমাদের 2001 30 জানুয়ারি 2000 এটা 4 of 2001। হ্যাঁ, ওইটাই তো ফাইল করেছে, দেখেন আমাদের পার্টি করেছে, তো আমরা করেছি, আমাদের তো পার্টি করেনি, এটা সনাতন সাহা। হ্যাঁ, ওরা করেছে, গোপাল স্যার। Yes. Lord, your lordship, আবেদন করতে their prayer. I'm ready. Your lord, it is there, it is exhibited. I'm showing.
Exhibit.
কত নম্বর exhibit? কত নম্বর exhibit?
Copy of the plaint.
Copy of the plaint.
Title suit number?
Title suit number 4 of 2001.
4 of 2001.
Lord, here parties are
filed by Pachkori.
No, parties by Sonatan Saha, Srimati Gopa Saha, the purchasers from Renuka Rani. Renuka purchased from Pachkori. Thereafter, Renuka transferred in favor of
Renuka sold to
Sonatan Saha and Gopa Saha.
Sonatan and Gopal.
The Gopa. Lord, the appellants herein. Lord, this Sonatan Saha and Gopa Saha, Lord, after filing our suit, 13 of 2000, Lord, they, after getting summons, in the meantime, without appearing in the suit, or appear and took time and filed this suit against Renuka Rani.
In the interregnum period, they filed this one 2001 suit
against Renuka, against their vendor.
And within the short span, they have obtained the declaration.
Yes, Lord, ex parte. Or that is, I think it was compromised amongst them. Collusion. Lord, your lordship, can you see here their declaration is. Yes, Lord, it is on record. I will point out, Lord, today I am just.
Mr. Ghosh, so the Bonton Nama is the crux between.
Bonton Nama is the crux. If Bonton Nama.
Satkori and Pachkori.
Pachkori. If Bonton Nama, the Pachkori's name is not there in respect of that plot, Pachkori has not sold it.
Once again, let us go through that Bonton Nama.
Bonton Nama, yes. Bonton Nama I have pointed out, Lord. So far the dag numbers are concerned.
Schedule in the Bonton Nama.
Yes. The Bonton Nama, Lord, the huge schedule. That's why I have just shown your lordship. Page 124, it starts. And Lord, Bonton Nama, not only Bonton Nama, Lord, held it by Pachkori. Lord, that is their compilation. Your lordship, just now, your lordship. Yes, yes. Lord, two things. Pachkori, Bonton Nama and Pachkori is held it in favor of Renuka.
No, let us first go through that schedule in the Bonton Nama.
Bonton Nama.
Partition deed.
Lord, page 124 it starts.
124, yes.
Lord, here huge properties
So let us first go to the schedule.
schedule. Lord, your lordship, kindly come to page 130.
130.
Yes, schedule starts here. এতদর্থে সুস্থ শরীরে সরলমন দলিল আদ্যপান্ত পাঠ করে এই বন্টনামা সম্পাদন করিলাম। এটি সন 1366 সাল, তারিখ 24শে ফাল্গুন, ইংরেজি 1960 সাল, তারিখ মার্চ 8 মার্চ। ব্লড প্রথম সপ্তম পদ। 1 নম্বর শ্রী 5 কোটি পাল, 2 নম্বর সাজান সাজ 7 ক তফসিল সম্পত্তি। ব্লড কাহিনী ক তফসিল সম্পত্তি যাহা প্রথম পক্ষ 5 কোটি পালের অংশগত। ব্লড নাম্বার 1, your lordship will not get here that property. These are other properties. Your lordship, the relevant page is, Lord, it starts and 5 kodi is continuing. 5 kodi is schedule, allotment. Now it will, your lordship, get it. 5 kodi is the relevant part. Lord, at page 137. Lord, your lordship will get one dag number by Shodo. At the bottom, 1090, 35 শতক,
35 শতক।
মাত্র and 21 শতক তো বাটে তো সুবর্ণ দাগে 24 শতক মধ্যে 12 অর্ধাংশ, মূল্য সাজান সাজ। Lord, here it ends. And Lord, your lordship will not get anywhere that batadag which was allotted in favor of Satkuri.
And lot kho commences from
Lord,
lot kho.
lot kho commences from, Lord, at page 138, Lord.
138.
Yes. Now, Lord, Satkuri's allotment is, Lord, your lordship, at page 139 bottom.
139 bottom.
Yes.
শ্রী সাতকড়ি পাল,
সাতকড়ি পালের অংশগত।
না,
Number item 1 starts, and your lordship relevant that food property at page.
So within the lot allotted to Pachkori, that 1085 by 2969 does not appear.
Does not appear, and Lord, in favor of held it in favor of Renuka. There also, Lord, schedule this plot is not there. Renuka, he got the allotment.
Might not have sold to Renuka.
It might have
he could have kept it to himself.
Yes, it may be.
So, but each and every plot will appear from the partition deed.
Yes.
That will clear the fact.
Yes. And Lord, now Renuka, which he has not purchased, against him a declaration suit has been filed. It was compromised within a short span of time, and it has been included rectification.
This 2001 title suit is between
Renuka and this Sanatan, her purchasers.
Renuka and Sanatan.
Yes.
How could they seek modification as regards to?
Well, that's why we are not made parties. Though earlier suit is filed by ours, declaration that it is our property, it has got, you have not got interest in this property. they, after receiving summons, took on time
To
for
file- to
filing
file
written statement.
written
But
statement.
at that relevant time, this mandatory provision was not there, that written statement should be filed within certain
With
specific time.
120.
Yes. In the meantime, this suit was filed by Sanatan and Gopa against their vendor, and it was compromised, saying there that we have also interest in this property. The deed was not correct. And now, after getting it, they filed written statement, and the contest is going on. If somebody, my lord, considers the basic thing, he'll not at all entertain their defense.
So, how far is the judgment passed in the 2001 suit
Yes.
has a binding effect upon either you, Satkori, or the purchasers from
It is
Satkori?
not binding, but on that basis, my lord, everything is proceed. And in the trial court, my lord, this suit was dismissed, our suit, on that basis. There we have preferred an appeal. We have succeeded in appeal. In the meantime, my lord, there was amendment, there was remand, everything. And now, my lord, the learned appellate court has held that yes, we are the real owner. They have no right title interest in respect to the property. Now they have preferred this appeal before your lordship. This is not the basic thing, as lordship has said. The basic thing, lord, key anchor is the partition deed and the deed of Renuka in favor of the deed of Pachkodi in favor of Renuka Chaudhary.
Mr. Ghosh, but the partition deed has been exhibited.
Yes.
Being exhibit number.
Lord, I am giving the exhibit list, Lord. Your lordship kindly yesterday, Lord, night I could not, because of a long gap. দুটো এক্সিবিট লিস্ট নিন, জয়সুকে দেখিয়ে খতম করলে হয় হিয়ারিং এর সময়। কটা বাজে এখন? Lord, today is, there's no time, Lord. On the next day, Lord, I give your lordship so that everything is at the very first sight your lordship can appreciate.
So the deed dated 9/3/1960, partition deed, is the crucial one.
Yes. And thereafter, Lord, Pachkodi's deed in favor of Renuka.
But everything comes from the partition deed.
Yes. Lord, as your lordship pointed out, that is the seat anchor. If there is no, it is no allotment of that Batadog is not in favor of Pachkodi, he has no right to say.
Through the partition deed, it is not allotted to Pachkori, then how can whoever it may be?
Yes.
Nobody can sell.
Yes. Lord, lordship, one another channel. On your lordship, I think, Lord, do not sit on 21st. 21st, Lord, your lordship is sitting on 28th.
here, but my learned friend who has appointed me, engaged me, he is not available. As the difficulty is that the man who has engaged me, he is not available. So I think there's a difficulty in protocol also. I cannot, probably cannot, my lord may refuse to hear me without the advocate on record of me. Anyhow, I am not taking those technical points.
No, that won't be the reason here.
No, I am not saying that. Just I am giving my predicament. Well, my lord, you would remember, we have argued it twice or thrice. My lord requested us, rather called us to file a simple notes
Written notes. Written notes.
that we have prepared.
Uh.
So naturally, my lord, instead of wasting my lord time, we can take a chance the any next available data is convenient to your lordship.
Mr. Basu is representing the respondent.
Yes, concluded.
Yes, already
Mr. Basu has concluded his submission, if I correctly remember. Mr. Basu, senior counsel, he has concluded his submission. My lord asked for the
written notes is required because
I know it has been prepared. It has been prepared, then I have to. That is the lack of coordination between myself and my friend. And can kindly accommodate no other alternative. I am otherwise ready. Well, but it will be repetition of the same thing. 2-3 suits are there, and moreover, the only point for consideration as per the rules framed by the division bench is whether the judicature affects the former defendant. The last, that is the only point. Appeal court went against me only on that point.
So,
there is against the former defendant, whether the judicature can be applied. There is no prayer against him, no relief against him. That is the issue framed. Last page of the paper book.
Yes,
that is at page at the order of 28/9/2021.
So from this end, I can only request that let written notes of argument be filed.
Yes.
Lordship, we shall also file the written notes of arguments.
When can it be filed?
Lordship, we can take 2
But
weeks
difficulty
time.
there are two. That something is beyond my lord's control and our control. We do not know that difficulty. My lord is now sitting in Friday.
No. On Fridays, this bench will be available.
Friday at 2 p.m.
So on 2 p.m.
Yes,
on 28th.
28th.
28th. Who is the advocate on record on behalf of the respondents?
Lordship, I am not aware.
Learned counsel,
I am on
don't say such things.
Apologies,
If
Lordship.
you are not aware.
But one thing can be done subject to my lord's kind consideration. I have prepared a list of dates in addition to what my lord has directed. So if my lord so considers, I can hand up a copy to to your lordship and to my clarification also. List of dates, it may assist your lordship.
Whatever, Mr. Ghoshal, you think that it will be assisting the court?
Yes, it will be assisting the court.
Dates, you are providing a copy to them also.
And just now I will give.
There's no hindrance in giving the list
it
of.
It will be additional assistance to your lordship, I think. কপি দিয়ে দিচ্ছি কেন ভাই দেখে নাও একটু সুবিধা হবে we should be systematic so that my lord is dealing with so many matters, so it is better to assist the lordship.
The fact is that it has been heard lastly on during the month of February.
To be very frank, we have all forgotten the basic thing. It's quite natural for a human being. You got to refresh the memory in a nutshell, and yes, that is
it is better to have a written notes of argument.
That has been doing. That has been done also. I have been told that it is ready.
Mr. Ghoshal, senior counsel, representing the respondents, furnishers.
Respondents,
Lordship, they are the appellants.
Representing the appellants, furnishes a list of dates, a copy of which has been also provided to the learned counsel representing the respondents. Full stop. Let the list of dates be kept to the record. Full stop. Full stop. On consent of both the sides, the matter is being fixed being fixed on
with universal
28th of November, 28th of November at 2 p.m. for furnishing written notes of argument.
I'm
So
grateful.
28th of November, 28th of November at 2 p.m. for written notes of argument.
Lordship.
You are also representing the only one set.
Senior advocate with Abdul Ali. With
As-
Mohammed Yunus. With
As both the sides have concluded the submission.
Mohammed Yunus.
Full stop. ঠিক আছে? এটা ওই লিস্ট অফ ডেটসটা
Just tell you.
এনভেলপে রেখে দেবেন, বুঝেছেন? এটা হিয়ারিং হলো 5 নম্বর আইটেমটা, 5 নম্বর
তোমাদেরটা দিয়ে দাও।
আমি দিয়েছি।
I'm taking leave of my lord.
Grateful Lordship.
চল।
নেক্সট অর্ডার।
My lord, I am for the respondent, my lord. I am led by Mr. Soumya Majumdar, my lord.
My lord, I
When
am for
he is coming, my lord.
I am for the respondent number
My lord,
19 and
after-
20. My lord, last occasion
On behalf of the appellant or appellants, it has been concluded. On behalf of the added respondents,
concluded. My lord, today we'll submit
Only
a
point
written
by-
notes of argument.
Huh?
We'll submit the written notes of
yes,
argument.
yes.
I'm led by Mr.
My
Chitti.
lord, I have served the written notes of argument when the earlier occasion, my lord.
Yes. Mhm. ওই তিন বক্সটা দেবেন, মানে ডকুমেন্টস দেবেন, ডকুমেন্টস এবং মজুমদার।
Yes, my lord. My lord, I have submitted before lordship the
Let them conclude.
written notes of arguments, my lord. My lord, after conclusion of the arguments, my learned senior, my lord, raised a question, my lord, that the grandson will have no power to file a suit, my lord. Only one question, my lord. The lordship come to the will, my lord, first.
Yes, the bone of contention is that the
Grandson has no right
grandson is not
to file the suit.
entitled to, not filing the suit,
Be entitled to
entitled to the share
Yes.
of a
all the Siddheshwar.
no, from whom he had directly inherited on the
Yes,
death of Sneholata.
Yes.
Sneholata.
Yes. My lord, your lordship can come to the will, my lord, first.
Will, yes.
Yes, my lord. My client is the grandson, my lord.
Grandson.
Yes.
Yes.
My lord, in the will, my lord, +1, my lord.
Yes.
আমার যে সকল স্থাবর অস্থাবর সম্পত্তি আছে তাহা আমার অন্তে কন্যাগণ যথাক্রমে 3 daughters, my lord, that is সরোজিনী বাসিনী দাসী, স্নেহলতা দাসী, আশালতা দাসী, 3 কন্যা সম অংশে প্রাপ্ত হইবে। মানে 3 daughters মানে উইল হ্যাভ রাইট, my lord, এবং তাহারা আজীবনকাল পর্যন্ত ভোগ দখল করিবেন। তাহাদের আজীবন ভোগ দখল করার পর তাহাদের গর্ভজাত পুত্রগণ, মানে 2 sons, my lord, and one have no issue, my lord, পুত্রগণ তাহাদের নিজ নিজ মাতার সম্পত্তিতে পূর্ণ সত্ত্বের মালিক হইয়া ভোগ দখল করিবে। ঈশ্বর না করুন যদি কোনো কন্যা সন্তান না জন্মায়, তাহার কন্যা থাকিলে সেই মালিক হইবে। যদি কন্যা না থাকে, অর্থাৎ যে সন্তান সন্ততিবিহীন হয়, তাহলে অপর কন্যাদের পুত্র কন্যাগণ সম অংশ তার সম্পত্তি পূর্ণ সত্ত্বের মালিক হইবে এবং তাহার দান বিক্রয় আদি বিবিধ প্রকার হস্তান্তরের মালিক হইয়া যথেচ্ছ ভোগ দখল করিতে পারিবে। মালের my client has the deceased grandson, my lord. There is no, in the will it is not stated that the grandson has no right, my lord. No right has not been stated, my lord, in the will, my lord. First one, my lord. And second one, your lordships kindly come to the, my lord, the please of the Siddheshwar Ghosh, my lord. The charge, my lord, I have given before your lordships, my lord, in the earlier occasion. There is no record in the will that grandson will have no right, my lord. And therefore, my lord, kindly come to the chart, my lord, Siddheshwar Ghosh, my lord.
Yes. You are referring to?
Is my lord?
You are referring to?
Referring, my lord, I am referring to Santosh Ghosh, my lord. My lord, one daughter, my lord, Sarojini Ghosh, one of the daughter, Santosh Ghosh and Prafullo Ghosh, my lord, 2 sons. There is no division in between the 2 sons. And my lord, Santosh Ghosh, my lord, my clan is Shati Mondol and Anima Koviraj.
Yes.
My lord, predeceased. Santosh Ghosh predeceased son, my lord. Therefore, my lord, Shati Mondol, Anima Koviraj. My lord, if that is so, my lord, Prafullo Ghosh, thereafter Shiva Prasad Ghosh, another son, and my lord, Somen Ghosh. He is also the grandson. His property has been taken by possession by my added party, my lord.
Where is
He is also the, my learned friend has come, my lord. My lord, senior, my lord, has come.
The intention
What is
of
that? You will be referring to Hindu succession?
I shall be,
Okay.
but I please see the will once. The intention of the testator carved out from a reasonable interpretation of the document. That's the test. But it's statutorily laid down in the 1925 Act, but not here the Hindu Succession Act applies. Third, the Indian Succession Act in sections 72, 74, 82, and 83 lay down the provisions in the manner a will has to be interpreted or construed. But the same is called out from various judgments, the intention of the testator to be found out from a reasonable construction of the will, and not the plain language decipherable therefrom. So please have a look at the will that the original has come.
Yes. Yes, Mr. Modi.
The first paragraph, the first marked paragraph. আমার যে সকল স্থাবর অস্থাবর সম্পত্তি আছে তাহা আমার অন্তে কন্যাগণ যথাক্রমে 3, here 3, the testator had 3 daughters, এই 3 কন্যা সম অংশে প্রাপ্ত হইবে এবং তাহারা আজীবনকাল পর্যন্ত ভোগ দখল করিবে। So it's a limited interest, life interest. তাহাদের আজীবন ভোগ দখল করার পর তাহাদের গর্ভজাত পুত্রগণ তাহাদের নিজ নিজ মাতার সম্পত্তিতে পূর্ণ সত্ত্বের মালিক হইয়া ভোগ দখল করিবে। So to the grandsons it goes for without any restriction. ঈশ্বর না করুন যদি কোনো কন্যার সন্তান না জন্মায় তাহার কন্যা থাকিলে সেই মালিক হইবে। The intention is to pass on the property to the granddaughter in the event there is no grandson.
Yes.
যদি কন্যা না থাকে অর্থাৎ this is explained. So if one of the daughters dies issueless, যে সন্তান সন্ততি বিহীন হয় তাহা হইলে অপর কন্যাদের পুত্র কন্যাগণ। So the intention once again goes back to be that the 1/3 share in respect of an issueless daughter is equally distributed amongst the grandson or granddaughter of the remaining two daughters. So to contend that only the sons will be entitled to the estate of the testator, this is not probably a benevolent interpretation or construction of the will.
That was not the intention of the
testator. And that's what exactly the first court and the first appellate court has found. The trial court and the first appellate court has found out. Now comes the question of distribution of the property. Now that will be finally adjudicated. It's only a preliminary decree.
So you are stressing upon that one, that ঈশ্বর না করুন যদি কোনো কন্যা সন্তান না জন্মায় তাহার কন্যা থাকিলে সেই মালিক হইবে। যদি কন্যাও না থাকে অর্থাৎ যে সন্তান সন্ততি বিহীন হয় তাহা হইলে অপর কন্যাদের পুত্র কন্যাগণ। You are stressing upon পুত্র কন্যাগণ, this word. সম অংশ তাহার সম্পত্তির পূর্ণ সত্ত্বে মালিক হইবে।
Intention was very clear. If one dies issueless, then the property goes to the rest two.
Yes.
Intention was never to deprive the granddaughters. Now, Lord, please take section 6 and 14, but these are the two provisions which may have some bearing on the issue. Section 6 of the Hindu Succession Act 56.
Network name, network succession. Yes.
But section 6.2 operates in a different field and 14.2 is an exception. But these are May I hands up? Oh, any.
It's a bit slow, but yes, I've got it.
I have the copy.
Yes,
Please have a
Mr.
look at
Majumdar.
section 6,
Section 6.
subsection 2. That Section 6 has a heading, devolution of interest in coercionary property. Subsection 2. Any property to which a female Hindu becomes entitled by virtue of subsection 1 shall be held by her with the incidents of coercionary ownership and shall be regarded, notwithstanding anything contained in this act or any other law for the time being in force, as property capable of being disposed of by her by testamentary disposition. Now please read this side by side with 14.2. Property of a female Hindu to be her absolute property.
Yes.
Any property possessed by a female Hindu, whether acquired before or after the commencement of this act, shall be held by her as full owner thereof and not as a limited owner. Now 14.2 carves out an exception. Nothing contained in subsection 1 shall apply to any property acquired by way of gift or under a will or any other instrument or under a decree or order of a civil court or under an award, where the terms of the gift, will or other instrument or the decree, order or award prescribe a restricted estate in such property. So it's a restricted interest which is in the estate which is passed on to the daughters.
Herein the general criteria are provided. We are to abide by the words mentioned by the testator in the will.
Intention to be culled out from a wholesale reading of the will. That this has been propounded by the legislators. That this has been time and again explained by the Supreme Court.
This is the basic.
This is the basic principle.
Basic principle.
So that I need not trouble your lordship with the judgments. And what my senior learned friend has relied upon that 2009 3 SCC, page 287, paragraph 33.
Envelope আছে না envelope? Envelope একটা না 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 envelope মানে এই রেকর্ডেড এই ফাইলের envelope সাইটেশন যেখানে আছে না 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 আছে ওদের সাইটেশন আছে সাইটেশন গুলো বোধহয় হ্যাঁ এর সাথে গাঁথবেন না এখানে গাঁথবেন না এনভেলপে দেবেন দিয়েছিলেন কপি দিয়েছিলেন পুরো বার করুন এই এরকম থাকবে না থাকবে এনভেলপে থাকবে হ্যাঁ হ্যাঁ সাইটেশন রিটেন নোটস অফ আর্গুমেন্ট সব এনভেলপে থাকবে হ্যাঁ yes they have cited
2009 3 SCC 285.
2009 3 SCC 287.
Yeah, I'm sorry, 287. Please come to paragraph 33 at 303. From the earlier court's judgment, from the earlier decisions of this court, the following principles inter alia are well established. In construing a document, whether in English or in vernacular, the fundamental rule is to ascertain the intention from the words used. The surrounding circumstances are to be considered, but the surrounding circumstances in this case would mean not to deprive the granddaughters as well. but that is only for the purpose of finding out the intended meaning of the words which have actually been employed. In construing the language of the will, the court is entitled to put itself into the testator's armchair and is bound to bear in mind also other matters than merely the words used. It must consider the surrounding circumstances, the position of the testator, his family relationship, the probability that he would use words in a particular sense. But all this is solely as an aid to arriving at a right construction of the will and to ascertain the meaning of its language when used by that particular testator in that document. The true intention of the testator has to be gathered not by attaching importance to isolated expressions, but by reading the will as a whole with all provisions and ignoring none of them as redundant or contradictory. So that if your lordship has to test the intention of the testator, that if this expression that deprivation of the granddaughters is to be read, then this will lead to a contradiction. The court must accept, if possible, such construction as would, now this is very important, as would give to every expression some effect rather than that which would render any of the expressions inoperative. The court will look at the circumstances under which the testator makes his will, such as the state of his property, of his family and the like, where apparently conflicting dispositions can be reconciled by giving full effect to every word used in a document. Such a construction should be accepted instead of a construction which would have the effect of cutting down the clear meaning of the words used by the testator. Further, where one of the two reasonable constructions would lead to intestacy, that should be discarded in favor of a construction which does not create any such hiatus. But my first and foremost submission is there is no contradiction. It has taken care of both situations arising out of not heirship. One, if any of the daughters dies issueless, what will happen? It will pass on to the remaining two. If one does not have a son but daughter, then the grandson and the granddaughters will be equally entitled to the estate of the testator. But this is exactly what has been found by the trial court and the first appellate court.
So you are also relying upon 2009 3 SCC.
And what the other judgments which my senior friend had relied upon in the
relied upon AIR 1963. AIR 1963 Supreme Court 1703.
That's already
AIR 1920 Privy Council page 103.
Those have been indicated and distinguished in our notes.
I'll give the compilation of all.
Compilation of
the judgments I've cited. I've cited on last day.
Notes on submission on behalf of the respondent number 1 and 2.
Yes, you have dealt with those judgments cited by my senior learned.
In addition, on behalf of the appellant,
this 2009 3 SCC was cited.
1979 3 Supreme Court cases 273, 2006 volume 13 Supreme Court cases 737 have been cited.
But these have been dealt with in my
notes of argument.
Please come to page 6 of my notes of submission.
Yes, paragraph.
Paragraph 16 deals with 2006 13 SCC. 17 deals with 79 3 SCC. 18 deals with 69 2 SCC. But the other judgment I have dealt with just 2009 3 SCC, which was probably referred to or not cited on the last occasion.
Copy has been served upon the Mr. Srivastava, anything in reply?
Yes, yes.
Only on the point of law?
Yes.
This is
I have compiled all the judgments.
No extra citation has been provided herein, apart from those which have been provided earlier.
One more.
One more.
No, I made the submission. The judgment was not. Last day I made the submission that the devolution opens on the death of
Yes.
the testator
Uh-huh.
or the
That is-
person owner. I have cited one judgment for that. Your Lordship will kindly take the written argument.
Which one is that? authority?
I'll refer. That is at page 13, Your Lordship will take of my written argument.
Yes.
C. Your Lordship has got that?
The devolution of the properties.
Yes. Only opened on the death of Saroj Basni and Snehilata and not earlier. And that on the date of their death, the persons under the will who are living shall inherit the property. Then I have cited that judgment,
You have cited
1979 3 SCC 273 at paragraph 19. Such ascertainment of heirs of the testator is to be done on the date of Nataraja's death without male issue, when succession opens out in favor of those heirs and not with reference to the death of the testator. On the date when Saroj Basni died, who are the persons entitled to her property is stated in the will. And then it is submitted. It is further submitted that when Saroj Basni died on 25/7/99, and on that day the succession opened on the death of the limited owner, and as such under the will, Profullo was the only uterine son. Gorbojat.
These are on facts.
Yes, on facts, but the law is that it will on the death of Saroj Basni.
Mr. Srivastava, you have
I've
submitted
made
this
that
to an earlier
submission.
date.
I've cited the judgment with regard to that. And then, Your Lordship, with regard to 14.1, my learned friend had submitted that. 14.1, it's the general proposition of devolution that the limited state of a woman will become absolute on coming of this succession act. But those limited state created by will, court order, and etc., that is 14.2, those states will not become the absolute owner. Absolute property of the lady concerned. It remains a limited state. And Your Lordship will see only when the property becomes absolute under one, then only the general law of inheritance apply. And granddaughters are class 1 heirs with sons and daughters, that is there. But the will is made to change that general law of inheritance. That is, and Your Lordship.
That has been submitted earlier.
Yes, and Your Lordship, the one I have submitted, that when the terms used in the will are clear, there is no doubt of interpretation or ambiguity, then that literal meaning is to be given effect to. And not an extended or some intentional meaning what was presumed. Who was there in 48?
These are the basic.
Yes. No, Your Lordship, what was the intention will come when there is ambiguity. So, Your Lordship, the will is clear. I've given everything. I've cited, I've given the Your Lordship the judgment. I've compiled all the judgments. And Your Lordship, one more thing. From the reading of the will, there is no mention of grandchildren. Your Lordship, kindly take clause 3 of the will.
Mr. Srivastava, once again going to the.
No. What I'm saying, the terms used in clause 3 also says about sons and daughters. And in the clause 1 also sons and daughters. Nowhere grandchildren or predeceased son. Your Lordship, the testator thought about if one of the daughters dies before him, predeceases him, what will happen to that state? He had made provision for that also. That is in clause 3. These are my sums. And Your Lordship, another aspect, the court did not consider that he has to declare, as per the CPC, Your Lordship, he has to declare the shares of all the persons in a partition suit.
Only the share of the plaintiff.
Everyone, or who are owners.
Only the share of the plaintiff has been declared by the trial court.
Yes, Your Lordship, but who are the first he has to decide in a partition suit who are the owners, co-sharers, and then has to declare the shares of each of them. He has not done anything.
Everything final.
Shares
has to be declared. Then only final.
In the preliminary decree, through the preliminary decree, the shares are to be declared.
Then only partition takes final.
Then comes the
First,
allocation of whether amicable or.
In the preliminary stage, he has to declare the owners and then the shares. That much. But here he has not considered that, because he did not consider that they are entitled to honor, the plaintiffs, under the will.
So we have concluded. Written notes of argument?
Yes, I have prepared. I have already handed over.
So if copy of the written notes of argument have not been, written notes of submission have not been provided, then
no.
Be kind enough to provide.
Answer DC.
It's okay. You accept that
Mr. Modindan, Senior Counsel, representing the respondents number 1, 2. Full stop. Has concluded a submission. Full stop. Mr. Srivastava, representing the appellants. It's such should reply. Full stop. Hearing concluded. Reserved for judgment.
Yes. Mujumdar, Leena Mujumdar.
Much okay.
Mujumdar, Leena Mujumdar for his. Wait, let me get. Here's your
বড় এনভেলপে এইগুলো রিটেন নোটস অফ আর্গুমেন্ট আছে এনভেলপে থাকে এগুলো তো বাক্সতেই থাকে এখন বাক্সে ঢুকিয়ে দিন লক রেকর্ড গুলো
হ্যাঁ ফাইলটা দেখে নেব অনেক দেখে নেব
আপলোড হয়ে গেলে অর্ডার আপলোড হয়ে গেলে কি বলে রেকর্ড গুলো পাঠিয়ে দেবেন যেগুলো সিএভি যে ক্যানটা মানে সেকেন্ড হ্যাঁ অ্যাবেটমেন্ট কি বলেছি কি বলে বলি Yes, item number 8. Presenting under the appellant or the respondent, the matter appeared on 14th of November. By the yeah, from the order book, it reflects that on 12/12/2024, 28/2/2025 and 7/11/2025, none had represented either the appellant or for the respondents. Full stop. Paragraph. For the ends of justice, the matter is being adjourned today. Let the matter appear on 5th of December 2025. Full stop. Paragraph. If on that day no step is taken on behalf of the appellant, necessary order shall be passed.
My lord, in this matter, my lord, Partha Sarkar appearing for the petitioner. He is engaged in 759 division bench. One matter is going. I am playing one day account.
You comments.
No,
You start.
I have not in the brief. He is calling me only. I have nothing about the brief.
Who is the advocate on record?
Partha Sarkar. I am not in the brief. One day account, not 759.
Lastly appeared on 8th May 2025.
Yes.
Thereafter, none represented the appellant.
I don't know, but only he said, he stuck me, he is in civil. He is
So
one
this
matter
will
is
be the-
going. Oh, chole eসেছিস?
In fact, my lord, last occasion, my lord was pleased to direct me, my lord, to serve notice, my lord, upon the Pradhan and the private respondent. My lord, actually, my lord, Served, my lord.
Take your breath.
I have, my lord,
Be
in fact, my
seated.
lord.
Be seated, take your breath, thereafter you submit.
Okay, all right. Actually, 4 times when I have served. In spite of that, my lord, nobody appeared.
There's a direction. There's a direction.
There was a direction, my lord. Lordship, kindly allow me some more time, my lord, so that I can serve afresh, my lord.
Um, the learned counsel representing the petitioner seeks an accommodation, seeks an extension of time to serve notice upon the secretary and the pradhan of Kamrabad Gram Panchayat. Upon the respondent number 7, Probir Pomdon.
Though I have served, my lord, twice, my lord, in spite of that, nobody appeared. If your lordship directs me, then I serve.
Last semester. Pradhan of Kamrabad Gram Panchayat, and also the private respondent, namely Probir Mondol. Full stop. Consider the submission. Full stop. The learned counsel is requested to take steps immediately as regards to service on the respondents number 5, 6, and 7, and to furnish an affidavit on this regard on 2 weeks time. 2 weeks. On 5th of December.
Much.
I'm for the HM, sir.
Item number 10. উনি ঠিকই বলছিলেন, ওনারটা তার পার্ট হার্ড, ওনারটা পার্ট হার্ড, দেখে নেবেন রেকর্ড, দেখে নেবেন রেকর্ডটা পার্ট হার্ড, কিন্তু মনে হয় যেগুলো পার্ট হার্ড আছে না সেগুলো পার্ট হার্ড আগে দিয়ে দেবেন। পার্ট হার্ড এদিকে।
In this matter, the petitioner prayed for
neither the petition of the private respondent number 5 and 6. The earlier two occasions that is none appear on behalf of the petitioner. For the interest, yes.
Matter relates to 177 proceedings for demolition of unauthorized construction. The petitioner prayed for implementation of the proceedings. He alleged that there is she alleged that there is a unauthorized construction, and so the demolition should be done. In the meantime, I have been informed that the petitioner died possibly. I don't know. I cannot.
Pratibha Mitro.
So and they are not also taking steps also.
Since
Last 2 occasions.
no 3.
3 occasions.
Last 3 occasions.
I may be corrected, but
since 2/12/2024.
Both the petitioners and the private respondent also not. Private respondent available.
No.
The private respondent also did not appear in the last occasion. In any manner, I appeared every time.
It is the duty of the learned counsel to intimate. It is the duty of the learned counsel to intimate the court. It is the duty of the learned counsel to intimate the court. It is the duty of the learned counsel to intimate the court. It is the duty of the learned counsel to intimate the court. It is the duty of the learned counsel to intimate the court. It is the duty of the learned counsel to intimate the court. It is the duty of the learned counsel to intimate the court. It is the duty of the learned counsel to intimate the court. It is the duty of the learned counsel to intimate the court. It is the duty of the learned counsel to intimate the court. It is the duty of the learned counsel to intimate the court. It is the duty of the learned counsel to intimate the court. It is the duty of the learned counsel to intimate the court. It is the duty of the learned counsel to intimate the court. It is the duty of the learned counsel to intimate the court. It is the duty of the learned counsel to intimate the court. It is the duty of the learned counsel to intimate the court What to be done?
Any order on merits cannot be passed. It can be passed only dismissed for default, nothing else. So far as I know, my lord.
Not intending to dismiss the
My
matter.
lord, as I leave it to your lord. I am also not on that, but in fact,
But ultimately, it has to be steps are not taken.
and it I am also doubting that the private respondents are not appearing.
Private respondents are not appearing.
And it is a allegation of unauthorized construction.
Private respondents are numbered as
Private respondent numbers, sir, my lord, 5 and 6.
5 and 6.
Yes, they are not appearing.
No, they had entered appearance.
They are entered appearance, but now both the parties regarding petitioner and private respondents are not appearing. So I don't know whether there is a settlement between them or not. I don't know.
If there is a settlement, it should also be conveyed.
If there is a settlement, that should not be, because if it is an unauthorized construction, settlement cannot be entered into. So far as I know the law, not in other cases, settlement always can be done. But here it is a doubt.
At least there should be an appearance of the learned counsel.
Should be an appearance.
Lastly,
They think that if dismissed matter is dismissed for default, nothing will happen.
10th of May 2024. Last chance. From the order sheet, it transpires that the petitioner has been lastly represented on 13th of August 2024. Full stop. On 12th of December 2024. 12th of December 12 12th of December 2024 and 7th of November 2025. None has represented the petitioner. Paragraph. In such circumstance, for the ends of justice, let the matter appear on 28th of November 2025, full stop. Paragraph. On that day, if none represents the petitioner, then necessary order shall be passed.
Yes.
I am for the state.
Petitioners are diligent proceeding this matter. Petitioners are found absent on previous days.
You are representing
private respondent.
Private respondent.
My lord, on the last occasion, my lord observed that
record data. For the state. For the state. For the state. The state. On the next date, necessary order will be passed. From the order sheet, it reflects by transpires that the petitioner is not being represented since 3/2/2025. On the last 1, 2, 3,
Previous lordship observed the next day matter will be dismissed if the petitioner remain absent.
Oh,
My lord,
such a-
pass the necessary order
which is,
last.
তাহলে এটা বাদ দিন। Yes, yes. On that day, if the petitioner is not being represented, necessary order shall full stop. From the order sheet, it transpires that the petitioner has been lastly represented on 12th of December 2024. Full stop. The petitioner has not been represented on 13th of February 2025, 25th of February 2025, 8th of May 2025, 24th of June 2025, and 7th of November 2025. Full stop. As it transpires that on last কতগুলো 6 না 13 থেকে last 5 occasions none has represented the petitioner, so petitioner seems to have lost interest in the list. As such, petition being the petition seeking
In the self-same matter, the petition is proceeding with the civil court. Self-same cause of action, self-same matter. Petitioner thought it prudent that it will be against him.
the present petition, the কি বললাম last address in the matter, as such, present petition is dismissed. 44.
Grateful.
Nobody.
দিন রেকর্ডটা দিন রেকর্ড তাই তো From the order sheet, it transpires that on the earlier occasion, that is on 7th of November 2025, none had represented the petitioner, and today also none is representing the petitioner. Full stop. For the ends of justice, let the matter appear on 28th November 2025. Full stop. On that day, if none represents the petitioner, necessary order shall be passed.
My lord, we appeared for the corporation on behalf of led by Mr. Sijan Nayak. My lord, since last 3 occasions, nobody appeared on behalf of the petitioner. My lord, private respondent filed an appeal before the tribunal, and appeal is pending. Let them reach application be disposed of by directing the corporation appellate authority to carry out the appeal as early as possible.
Yes. From the order sheet, it transpires that None is representing the petitioner since 12/12/2024. On last five occasions, that is on 12/2024, 13/2/2025, 25/2/2025, 18/5/2025, 24
July.
24/6/2025, and 7/11/2025. None has represented the petitioner. Full stop. Paragraph. In such circumstance, for the ends of justice, let the matter appear on 28th of November 2025. Full stop. If on that day none represents the petitioner, then necessary order shall be passed. On the next day, necessary order.
Appeal is pending before the tribunal. Let it be disposed of and directed to the tribunal to head out the matter as early as possible. So the appeal was filed by the private respondent against an order under section 430 of the
That is pending before the tribunal.
appeal is pending tribunal.
Necessary order will be passed on the next day.
I'm good.
Whether that fact has been brought in the list, whether that fact is brought in the list, whether that fact that the appeal is pending.
But I have, my lord, I have given an instruction that the appeal is pending.
On the next day, we will consider.
Oh, I'm good.
Lordship, item number 14 and 15, I led by Mr. Devashish Roy, some instruction is needed from the client. Or
you will obtain the instruction in the meantime. Let us start today.
Lordship, only last chance.
Let us start today.
Today he is not
Let us
available.
start today. You will obtain the instruction after today. Tomorrow you will obtain the instruction. Let us start today.
Lordship, I am not ready with.
Place your case.
Lordship, let it be.
My lord, your lordship, kindly see your lordship's earlier order, my lord. In each and every occasion, we have given notice there. Pursuant to your lordship's order.
No, notice has been served, Lordship.
Senate Counsel, have you seen your conduct? Lastly appeared on 13th of February 2025. Thereafter, there is no appearance on behalf of the petitioners.
Lordship, I undertake next day.
Yes.
Lordship,
Let us start today.
Lordship, I am not ready.
In the meantime, your senior will come.
Lordship, kindly consider, Lordship.
Senate Counsel, can 2 of 23, can 3 of 24. What are these?
My lord, can 2, my lord, after admission, they obtain an order of stay of the degree that till the disposal of the appeal.
Can 2 application for appropriate order.
Can 2 application for appropriate order means, my lord, not to take steps for evicting him without due process of law.
You are the?
I am the appellant, Lordship.
Appellant, what, tenant or something, licensee or what is that?
No, I am the owner.
You are
He's claiming the owner.
You are claiming to be the owner.
Yes,
And you are claiming?
I'm claiming for the owner.
Both of you are claiming to the ownership in respect of the
yes,
property.
Dispute with regard to the ownership of the property.
Sure. What has the trial court done?
Both the court we have decreed this to.
So, the trial court has decreed. The trial court has decreed.
Judgment of affirmance.
And the first appellate court has affirmed the decree.
Against that, my lord, they have preferred this.
Yes. Let us start.
Lordship, but
Paper-
today I am not.
Is there any paper?
Lordship, kindly consider, Lordship.
And if your lordship kindly adjourn this matter, then in that case, my lord,
Lordship,
his
next
lordship
day
kindly fix
I
it
undertake,
temporary date,
Lordship.
my lord, because in each and every occasion, my lord.
No, Lordship, I
Kindly
undertake.
consider.
I undertake, Lordship. I undertake. Next day I will.
You will keep undertake, then you will not
Are
come.
the advocate on record?
No, my junior
is
is
that-
the advocate.
Huh?
Suman Singh is the advocate.
Who
on
is the
record.
advocate on record?
My junior, Lordship.
And who will submit on your behalf?
Mr. Devashish Roy, senior counsel, Lordship.
Where is the advocate on record?
He's on the way, Lordship. Something happens.
ওনার নামটা নিয়ে নেবেন নামটা the learned advocate representing the appellants seeks an accommodation for this day only. Full stop. From the order sheet, it transpires that on the last two occasions, that is on 8th May 2025 and 7th of November 2025, none had represented the appellants. Full stop. For the ends of justice, the prayer made by the appellants, made on behalf of the appellants, is allowed. Let the matter appear on 28th of November 2025.
Lots
of
The last.
undertakes বলেছে?
Yes, your lordship kindly.
The learned
Yes.
counsel, the learned advocate representing the insert for them, representing the appellants, undertakes to submit on 28th of November 2025. Full stop. Consider the submission. Let the matter appear on 28th of November 2025. Full stop. If necessary or full stop, necessary order shall be passed if on that day adjournment is sought for. Necessary order shall be passed on that day.
Yes.
No accommodation.
No further accommodation.
It has not commenced.
No, it has not yet come. This is not what happened. My lord, 14 and 15th.
14 with 15.
14 and 15.
Deeply.
Number 16.
Correspondent 2 to 5, Lordship.
I'm for the respondent number 8 to 8.
And I'm for respondent number 1. The mention হয়েছিল কে বললো?
Has it been intimated?
Yes. But Lordship, someone was here, they told that perhaps this matter was mentioned in the morning. No one mentioned because we were not in.
Let me be clear. As regards to mentioning, only new matters are allowed to be mentioned. Apart from those new matters, nothing are allowed to be mentioned.
Because someone told us they
when
mentioned.
called, each and every matter, when called, someone is to appear
Lordship.
for the parties to apprise the court.
Lordship.
মেনশন করেছিল নাকি কোনো কিন্তু মেনশন তো আমি তো অ্যালাউ করি না
কেউ মেনশন করে মিথ্যে কথা বলবেন না তাহলে
ঠিক আছে নিন নিন the learned counsel you are representing
Respondent number 1, madam. I am Lordship 225. তুমি কার বলো?
Respondent number 88 to 80.
respondent number
88 to 80.
88 to 80 আচ্ছা ওনাদের নাম
একটা কাগজে এদের সবগুলো লিখে
the learned counsel representing the respondents number 2 to 5 provides a letter where there is an endorsement of the learned counsel representing provides a letter wherefrom it reveals that the date of hearing, that is today, 14th November 2025, has been intimated to the learned counsel representing the appellant on 11th of November 2025, full stop. Let the notice be kept with the record, full stop. In spite of service as a notice by the learned counsel representing the respondent number 2 to 5, none is representing the appellant. Full stop. What to be done?
whatever your lordship pleases.
If it is, then there will be several applications for the ends of justice. Let the matter appear on 28th of November, 28/11/2025, 28th of November, full stop. On that day, if the learned counsel representing the appellant does not appear, necessary order shall be passed. Is anybody representing the appellant herein?
Yes, Mr.
no.
Onimesh Dash.
At presently in the courtroom? He is the clerk.
আপনি কি Onimesh Dash? Oh, he is the appellant. I mean the client.
Oh, I thought. Where is your lawyer?
Mention করেননি।
এখানে আসুন, এখানে আসুন, এখানে আসুন।
আপনি এদিকে আসুন।
বাংলায় বলবো না ইংরেজিতে বলবো? বাংলাতে। এই কোর্টে শুধুমাত্র নতুন কেস মেনশন হয়, তাছাড়া যে ম্যাটারগুলো লিস্টেড কজ লিস্টে আছে সেগুলো মেনশনিং নেওয়া হয় না, ঠিক আছে? ওই জন্যে নিশ্চিত যে মেনশন হয়নি। আপনাকে লাস্ট চান্স দেওয়া হচ্ছে, এইটা আপনার উকিল বাবুকে আপনি জানিয়ে দেবেন। শেষবারের মতো সুযোগ দেওয়া হচ্ছে। 28/11 তারিখে ওই দিনকে কিন্তু হিয়ারিং হবে। সেই দিনকে কোনো অ্যাডজর্নমেন্ট মানে কোনো সময় দেওয়া হবে না, ঠিক আছে? প্রিপেয়ার হয়ে আসতে বলবেন, না হলে কিন্তু নেসেসারি অর্ডার পাস হবে।
লিখিতভাবে জানিস
For the applicant, your lordship.
For the respondents, my lord. I'm paying for only one.
Matter has not been called. Has the matter been called?
I beg your pardon.
Number 17. Yes.
And for the applicant, your lordship. I'm for the respondents, my lord. I'm only paying for 1 day accommodation, my lord, kindly.
They have completed.
Your Lordship,
I believe.
this has a connected matter. This is a connected application on the self-same facts. We are praying for
What?
on the self-same facts. There's a connected there's another application.
Application.
Yes, another matter of the self-same facts before your bench, Your Lordship.
Another matter means
SAT 153 of 2024. It is pending before your bench, Your Lordship. And we are praying for so that both the matters are tagged, Your Lordship.
what's the number of the other second appeal?
SAT 153 of 2024, Your Lordship.
Where is that record of SAT 153 of 2024?
We are not. I'm not only entirely sure, Your Lordship, but it is.
On the earlier occasion, that is on 2nd of December 2024, it was directed that the appeal, that the second appeal being SAT 153 of 2024, which has been preferred in respect of the self-same judgment, out of which this present appeal,
Section 5 allow হয়নি তো
second, this present
to clarify, my lord, sorry, my lord, I should have there. Probably the other second appeal was filed. One of the defendant was not initially party to this proceedings. The application under Section 5 of Limitation Act is also there. Whether, my lord, it is after this appeal is matured for hearing, that second appeal has been filed, my lord knows better than us. If a person is a party to these proceedings, whether for the purpose of delay the
SAT 153 of 2024.
There was a typing error, Your Lordship. Typing error, there was a mistake on our part, on the applicant's part. Typing error on the name of the applicant number 4, Your Lordship.
What has happened? Mr. Roy?
Yes. This appeal has been filed.
First of all, let this code be clear. Whether out of the self-same judgment, these two second appeals, that is the present appeal, SAT 356 of 2017 and SAT 153 of 2024.
Yes. Same.
Have been preferred out of the self-same judgment.
Self-same judgment, defendant number 4 and defendant number 5 individually. Now, my lord, kindly consider. So, two defendants filed separate appeals. One is matured for hearing, which is filed, and another is pending for under Section 5 of Limitation Act. As on this day, the second appeal cannot be taken into consideration because Section 5 is, even if the majority comes later, whether the Section 5 is not yet been allowed.
Is it running in the list that SAT 153 of 2024?
With your lordship's leave, my lord, I am for the appellant led by Mr. Arijit Bardhan, my lord. My lord, kindly take the order dated 22/5/2024. We pointed out a fact that some latches on our part. At the time of filing second appeal, my lord, though there were, my lord, 5 defendants.
22?
22/5/2024. কোথায় গেল?
এই যে তো তোমারই বিবৃতি হচ্ছে।
Or my lord, 22nd May 2024. Because my lord, last occasion we as we
22nd May.
my lord, second paragraph, my lord.
Hmm.
He further submits that
Department is not accepting the wakalatnama as because in the wakalatnama the said person has signed as Ram Prasad Mondol, which is the actual name of the said person, but in the cause title of the memorandum of appeal, his name is revealing as Prasad Mondol.
my lord. Yes, my lord, that Devi Prasad Mandal, my lord, what has happened, my lord, in the code below, my lord, there were 5 defendants. In the second appeal, my lord, inadvertently 4 appellants were there. One was left out. We pointed out to this bench, my lord, then honorable bench was pleased to grant us liberty to take step. Accordingly, we take step. But my lord, meantime, there is a delay. My lord, kindly take the, my lord, order dated 2nd December 2024. We filed a second appeal. My lord, it was running in the list before the Honorable Justice, my lord, Bivas Ranjan De. But my lords,
Not record. If any party places in the appeal, my lord, what the it is not
let me, my lord, both are arising out of same self-judgment. If there are
proceedings
two
to be
conflicts,
made is under the order 41 rule like 20. If any person left out,
my lord, last occasion we submitted that the learned senior of respondent side, my lord, objected to. They would not allow. Then the liberty was granted us to take a fresh step against the for that appellant. My lord, we filed a second appeal with a section 5. Grant us some more time, my lord. We will try to ensure, my lord, either the matter got be heard before that bench or be released to from that bench so that matter can be assigned to this court. Because we mentioned before the Honorable Justice Bivas Ranjan, your lordship has
order 41, and let can consider order 41 rule 20.
Let us not go into the order 41 now.
Yes,
Prior to that. First, you have submitted on 22nd of May 2024.
Yes.
As regards to discrepancy in the name.
Then, my lord, the liberty was granted because, my lord, Mr. Banerjee, learned advocate, represent.
Appellant number 4 has been inadvertently.
Yeah, Mr. Banerjee, learned advocate, my lord, second page, last paragraph.
1 minute.
Okay.
What is the actual name of the appellant number 4?
My lord, Ram Prasad Mondal. And the left out defendant is Devi Prasad Mondal. Devo Prasad. Devo Prasad? Devo Prasad Mondal, my lord.
Memorandum or appeal? In the cause title, all have been included. In the cause title,
my lord, only 4.
SAT in this present cause title, present appeal.
No, my lord, 4. Kindly take the, my lord, towards the bottom, my lord. Mother and 4 brother is there. Mother and 3 brother.
The appellants are Kamala Mondol.
That is mother of my lord. Other
Kartik Chandra Mondol,
yes.
Ganesh Chandra Mondol, and Prasad Mondol.
Yes, Prasad, my lord, is Ram Prasad. And Devi Prasad, my lord, your lordship will find out from the judgment of the appellate court that Devi Prasad is also defended and appellant before the, my lord, learned first appellate court. But my lord, Wakalatnama executed, but his name was not in the cause title.
Where is the name of that Devi Prasad?
My lord, trial court judgment, my lord.
No. In the cause title.
Devi Prasad name is no, my lord. Devi Prasad name is not there. That is
why not? Why not?
My lord, it was, my lord, on my mistake, my lord. I would appreciate because initially, my lord, we are not the advocate on record. My lord, subsequently we came in the record. My lord.
These things are well known from this end.
My lord, kindly take your lordship past an order. My lord,
can be expressed from here in.
My lord, we took initiative, my lord. It was pending before the Honorable Justice, my lord, Bivas Ranjan De. His lordship, my lord, superannuated, my lord. The matter could not be heard meantime. Each and every Friday matter was listed. Your lordship can check it. I can produce the cause list as well, my lord.
For whom
And my learned
learned
senior-
friend is appearing?
Submission is enough.
My lord, I can produce the order where service upon the respondent direction was passed. Thereafter, my lord, matter was not, my lord, heard. And my learned senior appeared in that matter. It's not that case. The wakalatnama was executed. I served copies upon them.
That is, well, that appeal has been filed just only on the ground that debate number 5.
That I could not fully express from herein.
They can file this application under order 4220. Here, my lord can.
Yes, then my lord, it was submitted before the bench that if my learned seniors are not going to object it, we will take out. Then my lord,
counsel, first of all,
my lord,
as regards to the name of the appellant number 4.
Yes.
What step have you taken?
My lord, we have then your lordship passed a direction to accept the wakalatnama.
And
No, we filed second appeal in respect of 4.
Let me go.
Appeal is judgment.
That order has been passed on.
My lord, that is, my lord, if your lordship kindly take 22nd 5/2024, second page,
That
last.
has passed on 22nd of May 2024.
Immediately we filed.
More than a year ago.
My lord, immediately we filed, my lord. It kindly take the next order.
More than 1.5 years
My lord, kindly take the next order, my lord. Kindly, please, my lord. On 2nd December 2024. I produce entire record before your lordship. Your lordship, please to record that the second appeal was filed within, my lord, the date was given on.
No, as regards to the name of that appellant number 4.
My lord, Devi Prasad, my lord, Mondal. Devo Prasad Mondal. The left out my lord, appellant. 4. My lord, in serial number from my lord, from the appellant, my lord, these appeals memo.
Roy, there are 2 brothers.
No, 4 brothers.
4 brothers. Prasad Mondal is different and Devi Prasad Mondal is different.
That I am asking.
That is precisely my lord.
Prasad Mondal is a brother.
Yes.
Whose name is there in the cause title?
Yes.
Appellant number
4.
Appellant number.
My lord,
Yes, appellant number 4. Prasad
Mondal is Ram Prasad Mondal at that date. That is why, my lord, his wakalatnama was not accepted by the department. Then your lordship directed.
Where from we will get that his name is Ram Prasad?
My lord, order dated 22nd May 2024.
No, from the judgments.
From the judgment. My lord, kindly take the, my lord, appeals court order, my lord, appellate court judgment, my lord. First page. Or my lord, suit court judgments. Decree ta kothay gel.
Kamala Mondal, Kartik Chandra Mondal, Ganesh Chandra Mondal, Ram Prasad Mondal, and Dev Prasad Mondal.
Ram Prasad.
Ram Prasad is the Prasad.
Degree is Ram Prasad.
Ram Prasad. So it will be Ram Prasad.
My lord, kindly see
Not Prasad.
Let the 5 name, my lord. Decree of the, my lord, suit court.
Decree of the
suit court, my lord.
Hmm.
The Prasad name was there. Then in the first appellate, my lord, we write it Ram Prasad. That is why, my lord.
He is one of the appellants.
He was one of the appellants.
He forgot his name only.
No, my lord, his name, my lord, initial name and my lord, the full name, the original name, my lord, that was the mistake committed.
Can you consider who is the sufferer? Can you consider that?
My lord, nothing was, my lord, subject to correction. Nothing was past
Suit
expertise.
for eviction.
No, my lord. The, my lord,
A deed which has been executed to some extent, say illiterate lady has been fraudulently directed to execute a deed in the favor of the defendant. Both the courts will have held that deed is void.
Without examining the, my lord, respondent.
1 minute.
They are
examining the.
I didn't get a chance to cross-examine her. One occasion, she stand in the chief. Next day, she fell ill. I didn't cross-examine her.
That what is the effect and how many times is granted?
My lord, cancellation of a power of attorney. Respondent number 1 executed a sale deed in favor of the predecessor in interest of the appellant. After lapse of 30 years, she found that no, that was not the deed, that was the power of attorney which was executed from her on the pretext of power of attorney.
Let us not go into these small things. How much time will you take?
My lord, that is, my lord, something, my lord, I can't, my lord.
It is within your.
My lord, last occasion also I submitted one thing I can, my lord, able to do is that I can mention before the, my lord, coordinate bench with the fact that another appeal is pending. If your lordship, my lord, release it, I can assign it before your lordship. That much I can do. And that was, my lord, exactly I did before the Honorable Justice, my lord, Vivas Ranjan De, but his lordship was pleased to hear me on the section.
Let this matter be released.
Well, release him. Was there for a moment, my lord?
My lord, I will not
My
pay
lord,
that, my lord. Rather, my lord,
I'm coming.
my lord, this is not true. My lord, order has been passed, my lord.
Appeal. Now, my lord, allow me to.
My lord,
what steps has to be taken?
what can I do, my lord? I can mention it before the
What
coordinate bench.
20? My lord, no, my lord. This is something, if your lordship direct to take steps in accordance with the, does it mean to file a separate suit and say, yes, I filed a suit pursuant to lordship direction, I'll stay all these proceedings. The same thing happens.
The senior is
That
taking two stands at two different times. Initially, when it was pointed out, my learned senior, Mr. Arijit Bardhan, submitted the same thing. Then, my lord, it was submitted before this bench that if they allowed us, we will ready to file it. Then they said, no, we will oppose, we will oppose. Then your lordship granted me liberty to take step. I filed a second appeal.
Order for Rule 33 will come. So, so I have filed a proceedings which is contrary to the law.
If I allow to say one thing,
they release the
give me 15 days time. Let me try my luck so that if I able to release it, I would assign it before your lordship.
Counsel,
my lord.
Not your luck.
My lord, otherwise, my lord.
Within 15 days.
My lord, if bench only assemble, my lord.
You will have to, because the cause which you have shown is not at all acceptable.
My lord, only one day I will get a chance to,
more
my
to
lord,
be-
mention it.
nothing
My
more
lord,
to
I
be
can
expected
understand,
from
my
this
lord.
end.
I am not, my lord, I am not saying anything, my lord. Kindly, my lord, be kind enough, my lord. I am praying before your lordship, my lord, because arising out of same self-judgment. If, my lord, that matter be heard by another bench and this matter, my lord, be heard.
And this has been filed in the year 2017.
Yes, my lord, immediately, my lord, kindly
that
see.
One, that one.
24. After
That is
it is matured for hearing.
Now 153 of 2024.
24.
So section. That is why, my lord.
My section 5 got allowed, my lord. What would be the consequences then of that appeal? My learned senior is appearing for them, my lord.
So
if they cooperated with me, both we will go and mention before the bench.
Appeal is not maintainable in the eye of law.
That would be decided by that bench.
So as of this, there is no appeal in the eye of law.
There is an appeal.
Section 5, without allowing Section 5, is there any existence of appeal?
Visible eyes, my lord, did not help.
Mr. Roy, let the matter appear.
My lord.
On 5th of December, Learned Council.
My lord, if one line positively, I need to take some order or something, my lord, so that I can produce that order before that bench, my lord. One order, my lord.
Is that required? That required?
My lord, so that, my lord, I can
If my
substantiate my
learned friend
urgency.
file an application over here, it can be sorted out here and now. This is nothing but a tactic is kept up for the purpose of
My lord,
delaying the
record my
hearing.
learned seniors. Tomorrow I am coming with that application.
Let the file order for 40 Rule 20. What is the
Record it, I will withdraw it and I will file that
It
application.
is not mine. It is a statute give him the.
I know that to give
Yes,
him my right, but it was opposed by you. That that can't be done by me.
Why is
this
that
way.
application before this court? So the oppose comes later. Is there anything before the court?
They are appearing, my lord, since I got an interim order. They didn't point out that fact. When the appeal got matured, then they start raising that point.
Whatever to be done.
My lord, I will.
Yes.
Has to be done within this month.
My lord, kindly record one line, my lord. I filed appeal.
Let me be clear. Whatever has to be done, that has to be done within this month.
I will, my lord. I will.
Otherwise, necessary order will be passed on 5th of December.
Kindly
me be
record,
clear.
my lord. I will try, my lord. My lord, kindly record. I filed the appeal, my lord, so that I will, my lord.
That is already noted in
My lord, this
right order
because I
dated
have to bring.
2nd of December
My lord,
2024.
your lordship recorded, my lord, in this order because I will mention, my lord, before the coordinate bench, my lord, with that order, my lord. that the matter is pending before and date fixed on December 5th, my lord, so that I can, my lord, get my matter heard before 5th or that bench, my lord. It's not something, my lord.
It is up to you. It is up to you what you will do. That is your concern.
A date fixed on 5th, my lord, that much, my lord.
The learned counsel representing the appellants. Where were you during the last two occasions?
My lord, last
On,
occasion, my lord, I did
11th of February, 11th
last
of
occasion, my lord, I
December,
failed.
and 7th of November.
7th of November, my lord. Respondents are also not appearing, my lord. Last
Yes.
occasion, my lord, kindly see February's or December's order, I only appeared, my lord. They didn't appear. Last occasion, my lord, I didn't appear, my lord. I admit that. I failed to appear, my lord.
Let me be clear.
My lord.
As regards to this
Appeal, my lord,
appeal,
I need to, my lord, take.
apart from hearing, nothing else will be considered.
My lord, I will.
Careful to lordship.
Section 5 hearing.
No, my lord. Appeal otherwise
nothing.
ready for
Otherwise
hearing.
will be-
Ready.
Paper book also filed.
Paper book filed.
My lord, I have filed.
Paper book আছে paper book আছে আছে
হ্যাঁ ইয়ে পাটা বাঁধা এটা ছিল
exhibits
Yes,
Everything.
LCR.
LCR is there. Found complete.
have you gone through?
Yes, my lord, we have.
The learned counsel representing the appellants seeks an accommodation for this day to take necessary steps, all necessary steps so that the matter can be heard, can be taken up for hearing on the next date positively. On the next date, full stop. Okay. Consider the submission of the learned counsel. Let the matter appear, paragraph of it. Consider the submission of the learned counsel. Let the matter appear on 5th of December 2025. Full stop.
Grateful to lordship.
Grateful.
But on that day, there should not be such submissions.
No, my lord, I will, my lord, I will, my lord, try to, my lord, take something. Great.
Respondent.
Great. চারটে পাটে আছে